call to order the Monday, November 1st Development Review Commission meeting. Our first order of business is the roll call. Kat, could you call the roll?
Cher.
Here.
Arthur.
Here.
Silent.
Here.
Berardi.
Here.
Poinsett.
Here.
Sangri.
Here.
And Mr. Smith is absent this evening.
Good evening. Our first order of business is to have a council activities report from Aaron Ropp, and he's on the telephone. Aaron, can you hear us?
Loud and clear. Can you guys hear me?
The floor is yours.
All right. My apologies, I can't make it tonight. Just got home from work, and just my stomach wasn't feeling great, so I didn't want to abundance of caution, stay at home. So I appreciate Kat and all allowing me to call in. Quick couple updates from the last two council meetings plus a special session. So on October 5th, the big item that we discussed was getting an update from the city staff on the wastewater treatment plant, specifically going through the results of their geotechnical analysis that the city staff and our consultants did on the project, as well as getting some information on the environmental studies they did, as well as making sure that the project is making sustainability a priority. So it was a long, lengthy conversation and update with our partners in Canada who are helping us put the project together, but everything's moving according to plan. The staff and the city council made sure that throughout this process we have several opportunities to, if costs became too much of a prohibitive issue, we have off-ramps, we call off-ramps, or opportunities for us to kind of pause the project. But so far everyone's really happy with the progress, and Anthony Hooper is doing a great job managing the project for us. So a lot of great stuff. I look forward to updating you more as that project moves along. Let's see, on the following council meeting, if you haven't heard, the city has taken over the Seek Park property near right across the street from Musher Farms. And so the conversation on the 19th was really around getting an update from Parks and Rec Department, Ivan Anderholm's group, about what the plans are for the park, what we can do to it, what this community wants from the project and the park. And the big topic that we really spent a lot of time on was we got a lot of input from the community that they want a robust skate park for the space. And so getting information from Ivan and his team about how we integrate a really first-rate skate park into the property, as well as having soccer fields and baseball fields and turfs and all the other amenities that make all our parks in Lake Oswego great. So the good news is unanimously this council was in favor of pursuing the skate park and the larger skate park footprint because we don't have anything for that sport in the city. So so the staff is going to put together a proposal for what we can do and how much space we have to allot to it. So really looking forward to that the Receipt Park project coming down the way. And then the following day, the city council had a special meeting to wrap up our community policing outreach and recommendations. So it was a open forum. Anybody from the community could come in. We had it was on Zoom, so we had breakout rooms where each council member and staff hosted probably 15 to 20 other people, and we got the city or the community's input on what they thought about the report from our outside consultant, what they liked, what they didn't like, if they thought that there was more or it was robust enough. So really some really great feedback. And, once again, Lake Oswego has just a great community that wants to be involved in the city and how it works. So it was really great conversation, discussion. Next steps with that is the city staff is going to take the recommendations that we have and put hard action items into place on how we move forward with those recommendations. So this is certainly not the end of the road with our community policing dialogue. It's more of a where do we go from here? And what we are committed to as a city council is constant community engagement and continuing to hear from the people that live here about what they want out of their policing. So with that, it's a short update. I'm available for any questions if anybody has any.
Thank you, Aaron. Any
My
questions? Craig?
Yeah. Hi, Aaron. Hey, last meeting you mentioned the $8 million windfall from the federal government. Is that still going on as far as how to allocate that, what to do with that money?
We're still, the big item that we're waiting on is how much the North Shore Bridge is going to cost to repair. I believe right now the engineers are working on determining that. If you go over to the North Shore Bridge, there's people over there constantly working. So we are getting the money. How much we have, as you know, as I mentioned, the bridge is what's going to cost the most for us. And so once we have an idea of what that estimate's going to be, we're going to be able to figure out if we have money left over to allocate to the other special projects that we really want to do, like roads and pathways and other items like that. So we definitely are getting the money, and we definitely have plans for the money, but the big item is figuring out what the bridge is going to cost.
Aaron, could we double the budget for the DRC?
I will look into it. I'm a big fan of it. I think you guys do good work. You at least deserve it. So I'll see what I can do.
Oh, what a politician. Anybody else? Aaron, that's it. Thank you.
My pleasure, everybody. I'll see you. Hopefully I'll be well enough to come next time. So be well. Keep doing good work, everybody.
Thank you. For those of you that don't know, we have no budget, so if they doubled it, would still be zero. Okay, our next order of business is minutes from October 4th and October 18th. If there's no questions, I would take a motion to approve both.
I'll make a motion to approve both minutes if there's no changes.
Second.
Kat, could you poll the commission?
Shear,
Yes.
Arthur,
Yes.
Stylen,
Yes.
Birdy,
Yes.
Poinsett,
Yes.
Singh,
Yes.
Thank you. Our next order of business is the public hearing for LU 21-0016, an appeal of a staff decision on a request for a formal code interpretation of LOC 50.01.006, non-conforming structures. This site is located at 3300 South Shore Boulevard, tax ID number 21E17AB02300. The staff coordinator is Evan Franstad.
Thank you, Chair. This time I'll read the rules for the hearing this evening. This land use request is to be considered based on the applicable criteria and standards. The staff report lists criteria and staff identified by staff applicable to the request. It was available online and from the planning department. Testimony and evidence must be directed towards applicable criteria. Please specifically identify to the Commission the criteria or standards you are addressing so the Commission may consider your testimony in relation to the criteria or standards that you are addressing. If you do not identify the criteria or standards you are addressing, the Commission is not obliged to guess which standards or criteria you are testifying about and may not consider your testimony in its decision. Failure to raise an issue accompanied by statements or evidence sufficient to afford this Commission and the parties an opportunity to respond to the issue precludes raising the issue to the City Council and the Oregon Land Use Board of Appeals based on that issue. The failure of the applicant to raise constitutional or other issues relating to proposed conditions of approval will with specificity to allow this Commission to respond to the issue precludes an action for damages in circuit court. The public hearing process is as follows. There will be a presentation by staff, testimony by the applicant up to 20 minutes, testimony by parties in support of the application, then testimony by parties opposed to the application, and then testimony by those neither for nor against the application. Individuals will be allowed up to 5 minutes. Any person in attendance may cede his or her time or for testimony to another person except to the applicant. but in no case shall any person's testimony be increased greater than 10 minutes. Recognized neighborhood associations, homeowner associations, government or government agencies, or other incorporated public interest organizations will be allowed up to 10 minutes. Applicant's rebuttal, up to 5 minutes. Then commission deliberation, a statement to the applicant by the commission of proposed conditions of approval different than those contained in the staff report, and applicant's response to the commission's conditions of approval proposed following commission deliberation. Time limits do not include time spent responding to questions from the commission. Testimony by attorneys, representatives, and witnesses on behalf of or which are part of the presentation by a person shall be counted within that person's time limit. It is assumed that persons are testifying on their own behalf unless they expressly identify the recognized neighborhood association, homeowner associations, government or governing agency, or other incorporated public interest organization they are representing. A potential conflict of interest is declared on behalf of each of the DRC members to the extent of their business or employment, which each will identify. Unless declared otherwise, the respective DRC member does not have a known, present, or anticipated future business relationship with the project or applicant. It is possible that a future business relationship could arise in the initiation, design, construction, or maintenance of the project through either the employment or business of the DRC member personally or through a relative as defined in ORS 244.020. At this point, I'll direct to the body, please declare if any of you have an ex parte contact, including site visit, bias to this application, or a financial conflict of interest.
Okay, thank you. I'll go first. My name is Jeff Shear. I am a longtime Lake Oswego resident. I'm a retired contractor. I've had no ex parte contacts. I have no bias, no financial conflicts. I haven't made a specific site visit, but I drive by the site probably 4 times a day. Randy?
Thank you. I'm Randy Arthur. I'm a civil litigation attorney with the Portland office of Bullivan Bailey, PC. I have no financial conflict of interest and no disqualifying bias. I've had no ex parte contacts. I've made no specific site visit. Although I think within the last decade, my wife and I at one time looked inside this house when it was listed for sale. And I have gone by it occasionally, I think on the Blue Heron Canal. And I formerly served on the Planning Commission and chaired the Planning Commission and was on the commission from 2012 to 2018.
Bruce?
My name is Bruce Poinsett. I have no financial, well, I should state what I do for a living, shouldn't I?
Please.
Okay, so, thank you. I am a construction safety consultant, retired, semi-retired. I'm also a faculty member of Portland Community College, construction. And have never visited the site. I have no ex parte contacts, no biases, no financial conflicts.
Craig?
Hi, my name is Craig Berardi. I'm a financial consultant. I've not visited the site, but I live in that area and drive by it a couple of times a week. I've lived in the community for 25 years, so a lot of drive-bys. I have no bias, no conflicts of interest.
Mark?
My name is Mark Silen. I'm a local business owner, and since our last meeting, I am now in the employ of the Intuit Corporation. I have not made a site visit. I have no ex parte contacts, no financial conflicts of interest, and no disqualifying bias.
Dwight?
My name is Dwight Sangri. I am a new member of the commission. I am a retired civil engineer, and I have lived in Lake Oswego for almost 30 years, and at my first residence drove past this property frequently, so I am familiar with it. I have not ever been on the site. I have no financial or ex parte or potential or past business relationship, and therefore feel I have no conflict and no bias.
By the way, welcome to the commission.
I'm trying to learn all the words that I'm supposed to say.
Jason?
No, this is my first meeting too, so I've got a script though. At this point, I'll ask the audience, is there any challenge to a commissioner's right to consider the application? At that point, I'll turn it over to the Evans.
1 minute, Evan. I see we have some people in the audience tonight. If you want to speak, Kat, are these where?
Yes, we're doing paper tonight.
Okay, so you need to fill out a little slip of paper and say whether you're for or against, so we have a record of who you are and that you can speak. And these pieces of paper are?
Right back there?
In the back.
Yes.
And then you hand them to Kat. Evan, it's all yours.
Thank you,
Evan.
Mr. Chair and members of the commission.
One more thing.
Oh.
Jason, pardon me, you're the timekeeper. Okay. It's all yours.
All right, I'm on the clock.
No.
Thank you, Mr. Chair and members of the commission. Before I begin my presentation, as discussed in today's staff memo, there are two new exhibits to enter in a record. Those are exhibits G100, which is a public comment in favor of the application, and exhibit F14 is the applicant's testimony. In addition, I was also handed this stack of papers by the applicant, and this appears to be, just going through it quickly, evidence that's already in the record, but without going through each page, I don't really know. I can tell the table of contents is new, but everything else I think is already entered in the record, was submitted with the original application. But this is new. I have to verify. So the question is, do we want to should we continue this hearing to look at this and give it to you beforehand? Or should we continue on?
Well, unless you can verify that it's all in the record already, then we're going to need to do that either tonight or continue the hearing in order to.
Okay, so who makes that decision?
Well, if you can't verify it now.
I believe it's all in the record, but I would have to double check. Yeah, I can't say for sure.
All right. Then with the applicant's attorneys, I think then then both of us would request the record to be left open so you can submit this additional material if there is anything additional that we could then respond
Let's just
to.
talk about at the end of the hearing. I might just withdraw it if he thinks it's already in the records.
Yeah, I mean, that's the question. So,
Well, wouldn't the applicant know if it was in the record or not?
Well, the city lost my original filing, so I don't know whatever got in the record, so that's the problem. I didn't know it was online either, so I just brought it as a backup. If it's already in there, I don't need to submit it twice. So it's all the stuff that I submitted with the original application, which I was told was lost. So.
No, it was never lost. It just, it was misplaced during the move. It was submitted when we were moving city halls. But there was also an electronic copy of everything submitted.
but just the record for the commission is what's online and listed as exhibits.
That's right.
Okay. So unless you can look at that while we're sitting here and see whether you like that, then we'd have to talk about continuance at the end of the session.
Okay, let's talk about it at the end.
Okay.
Okay, so moving forward. Okay, so before I formally begin with the site features and background, it's worth noting that unlike a development review permit application, a formal interpretation application is application with specific site conditions are frequently not relevant to interpretation of code text. The task is not to apply criteria to a development proposal as you're typically used to. Rather, the question is, what does the specific code text mean that applies? I'll give a brief overview of the history and of the property and context on the reason why the formal interpretation is requested. So here's the site. It's located on South Shore Boulevard, which is to the north, and Cedar Road to the west. The site is zoned R7.5 and is developed with a single-family dwelling and a carport. The front yard setback is 25 feet from Cedar Road. South Shore Boulevard has a special street setback that is measured 40 feet from the center line of the right-of-way. The required street side yard setback along South Shore Boulevard is 20 feet measured from the special street setback. The side yard setback is 5 feet from the southwest lot line. The problem you're looking at is from a 2014 residential infill design variance application that was approved to remodel and construct an addition to the existing dwelling and reconstruct the existing carport. The existing shed that was identified by the applicant as a reason for the request for a formal interpretation was considered to be non-conforming to the special street setback, special side yard setback, and side yard setback. The writ approval did not grant any variances to the accessory structure. The approval did include a condition of approval regarding the accessory structure that was a recitation of the normal non-conforming standards. In 2016, a building permit was issued for the development approved by the RID, which also included rebuilding the accessory structure in error. The variance approval did not include or authorize the removal or reconstruction of the accessory structure. For reasons unknown, the applicant did not move forward with the project, the different property owner at that time, and the building permit and the RID approval expired in 2018. In 2019, a building permit was issued for the same plans as was submitted in 2016. They submitted the same plans as before. The accessory structure was then demolished and a new foundation was poured in the same location. A short time later, when planning staff discovered the error in issuing the building permit for the reconstruction of the non-conforming accessory structure, a stop work order was issued on the building permit. The applicant had noted good faith and reliance on the building permit in leveling the accessory structure and not allowing the applicant to build a new structure to the same degree of nonconformity is grossly unfair and inequitable. The applicant has stated that building permits should not be revoked by the city unless it wishes to pay resulting damages resulting from that decision. The question in this formal code interpretation is limited to the interpretations of the code provisions, specifically the non-conforming standards, not to rule on the fairness and equities of the case. The commission is to determine what the code text means, whether the city or the applicant bears a responsibility or liability for circumstances that gave rise to the filing of the interpretation, or what the consequences are to the applicant or the city resulting from interpretation are not before the commission. The commission is not to adjudicate the causes, liabilities, and remedies of the applicant or the city. So this brings us to the original request. The applicant originally requested a formal code interpretation to interpret the Lake Oswego Code to determine whether the non-conforming use right to reconstruct the applicant's accessory structure still exists. I should note that the requested interpretation would apply to any structure that's non-conforming, where non-conforming standards apply, not just the applicant's accessory structure. So it's tempting just to look at this one shed, but no, it applies across the board to any non-conforming structures that would apply. So this could, for example, could be a non-conforming accessory structure in the setbacks like we're talking about today. It could also be a two-story house that's non-conforming to maximum height or lot coverage or floor area, any standard we have. So just keep that in mind that this applies to interpretation of the code overall, not just for this property. Non-conforming structures are structures that at one time were legally constructed. Then the standards changed, and the structures are no longer permitted except to the degree permitted by the non-conforming regulations. The non-conforming regulations are a means to mitigate the effect of change in the zoning standards by allowing continued use and maintenance, but affect a phase out of non-conforming structures through attrition due to limits on repair and reconstruction. The reason for this is non-conforming structures in some measure do not promote the general welfare, do not result in development in accordance with the comprehensive plan, and have the potential for adverse impacts on surrounding uses. Staff's formal interpretation issued in the staff report dated August 27th was, where a landowner voluntarily undertakes a reconstruction project and dismantles a non-conforming structure in the process of rebuilding, the non-conforming standards does not result in a transfer of nonconformities from the removed nonconforming structure to a replacement structure. The second one is the applicant states and the staff agrees that LOC 50.01.006.4A4, which is damage and reconstruction of nonconforming structures, does not authorize such a transfer of nonconforming rights. And lastly, the penalty standards in 50.09.002.3 do not apply to the suspension or revocation of building permit. The bill request for public hearing included 3 additional issues raised. I'll go through each one of those. All right, so the first issue in their words was when a landowner seeks to change the roof pitch of a non-conforming structure consistent with 50.01.0063A4, which is in front of you, is the landowner allowed or required to make whatever resulting structural and foundational upgrades needed to both support the new roof and to comply with the current version of the Oregon Specialty Structural Code, AKA the building code? As stated in the code, for residential structures, a change in roof pitch on a non-conforming portion of the structure may be permitted if the roof height is increased by no more than 6 feet and does not extend the base zone height. Staff finds that change in roof pitch pursuant to this section does not authorize dismantling a non-conforming structure to its foundation and new construction that does not conform to the code in order to change the roof pitch. If foundational or structural upgrades are required by the building code in order to support the change in roof pitch, that would be more than a change in roof pitch under this section, and new construction must conform to the code. Issue number 2 is about maintenance. Here's the definition of maintenance in front of you. The issue that they state is the landowner allowed to make changes to a non-conforming structure that do not increase the degree of non-conformity when those changes fall outside the definition of mere maintenance, but which do not constitute an expansion of non-conforming use? If so, is there anything in the code that prohibits the landowner from rebuilding a non-conforming accessory structure from the foundation up if that amount of work is needed to support the new roof pitch and to make the building safe and habitable? So as you can see, definition in front of you is upkeep and repair of any structure or site feature necessary to keep the structure or site feature in good and safe condition. Maintenance does not include structural alteration, which I underline that for emphasis for the next definition, unless that structural alteration is required to remedy a condition declared to be unsafe by any official charged with protecting the public safety upon the order of that official. So that leads us to the definition of structural alteration. And that says a change to supporting members of the structure, including but not limited to foundation, bearing walls, bearing partitions, columns, beams, girders, or the roof. Staff finds that only change permitted to non-conforming structure is a change to the roof pitch that does not encompass rebuilding new construction from the foundation up. In fact, rebuilding without expansion was presented as an option to the Planning Commission in 2009 for potential code amendments to the non-conforming structure standards and was not adopted. So the legislative history backs up this finding. The intent was to allow only a change in roof pitch. As was the case in 2014 RID approved on this site, and as standard practice, normal maintenance repair that does not include structural alteration is permitted. That's such as replacing siding or replacing a window. Nothing that is structural unless it's the roof and it's for a change in pitch. So the third item involves that very long section of the code. I'm sorry for that. The question is, can the general conformance with the code provision before you be interpreted as authority to interpret code sections that authorize development action as included as an implied negative, i.e. an implied prohibition with regard to potential development actions not mentioned in that provision? Staff finds that this provision is an express prohibition of any construction, reconstruction, or alteration that does not comply with the requirements of Chapter 50, which is the Development Code. There's no implied right to construct, reconstruct, or alter structures, especially non-conforming structures that do not comply with Chapter 50. And with that, I will hand it over to Deputy City Attorney Evan Boone.
Thank you. Thank you, and I'll just kind of walk the commission through what I think the methodology is for its analysis, and then through the code criteria that's being addressed. I guess I want to say at the outset that, of course, this is a request for a formal interpretation, so the really, as far as criteria, the question is how should the code be interpreted? The request for formal interpretation started with their application, which included, I think, 8 different sections to be interpreted. And I think that's kind of been winnowed down through the staff decision and then through the appeal to, I think, 2 sections, really, kind of before you. But we really ultimately will need to address, I suppose, all 8, perhaps by adoption of findings, staff findings. Anyway, the methodology to interpret the code, which I think Mr. Stamp agreed, that it is through text. You look at the text of the code. Well, you're trying to figure out what the council meant when it adopted this thing. So how do you do that? You look at the text, the context, that is how the words are used in the scheme of things, the legislative history, and if necessary, then the rules of construction. And the staff report of August 27 kind of goes through that step by step for each of the provisions. Now, what that means, of course, is if we're looking at text, context, legislative history, and rules of construction, then the individual circumstances of the applicant as to what brought this case before us and what may happen in the future is not before the commission. The question is, what do these words mean? And that question could have been asked in 2014, the original RID, could have been asked by the applicant before they filed the building permit. We have it here after the building permit, sort of thing. So, and it will be asked by others when they file, or when they're considering their non-conforming structures, or neighbors when they're considering non-conforming structure activities. So there's a statutory scheme, and as indicated, I start with 50.01.022. That's the compliance section, and that says that nothing shall be built, constructed, reconstructed, rebuilt, enlarged, altered, etc., that does not comply with the code. So we start with that. So there needs to be some authority in the code to proceed with the construction. And then under the non-conforming structure section, non-conforming section 50.01.006, if you have a non-conforming structure use or site feature, if there wasn't a non-conforming section, then everything would have to conform immediately upon adoption of the ordinances. That would work a hardship to property owners, and so since 1946, when we started our zoning ordinance, and consistent with other jurisdiction, there's a non-conforming use section. The non-conforming use section is what authorizes the use and changes to non-conforming structures. So we have to look to that text based upon the compliance section, then we look at the non-conforming uses of what you can do with those. The applicant has cited a case, McKay Creek, which we've indicated in the staff report, I don't think is applicable. That's a case which talks about whether or not a county's code, which expanded the reconstruction rights of a property owner with non-conforming structures, as to whether or not that was permissible. The court held that the statute which applied to counties was not a limitation on counties. The counties could in fact adopt code beyond that, and so they held that the county's ordinance, which allowed the reconstruction of structures beyond what the statute did, was lawful. Fine. I don't have any problem with the case. That's a question as to whether counties have exceeded their statutory authority, whether it's that sort of thing. So I don't think that's really relevant to the case. So walking through, and if you could go to continuation, so that's back one. Yeah, back one. So when we're looking at nonconformities, we kind of go through, there's 4 sections of it, so I'm going to take us quickly through there. Continuation, under 2A, we've said in the code, the party has a right to continue to use a structure so long as it remains otherwise lawful. Okay, so they can continue to use it, that's what usually happens with non-conforming structures. Okay, next one. Next thing a person can do with property with non-conforming structures is to maintain the structure, to maintain the non-conforming structure. Now, the rights that you have on the maintenance section are interesting insofar as I can maintain the structure in a manner not in conflict with other provisions. Okay, so I just keep maintaining it. However, that also says that nothing shall be deemed to prevent the strengthening of it if necessary, to restore it to a safe condition, if declared to be unsafe by any official charged with protecting the public safety upon order of that official. Shorthand, the building official would determine that the maintenance section does not prohibit somebody from restoring property that's been declared to be unsafe. We'll see that also, I think, in the actual text and we get into structural alterations, right? So that deals with maintenance. So what is maintenance? Well, maintenance is upkeep or repair necessary to keep it in good and safe condition, okay? Does not include structural alteration unless the building officials declared it to be unsafe, okay? So under maintenance, I can maintain the property, keeping a good condition. I can't do any structural alteration unless the structural alteration is necessary in order to keep it safe as declared by the building official. Now, that seems like somewhat of an anomaly as to, well, doesn't that then just encourage property owners not to maintain their property until it gets to the point where a building official will declare it to be unsafe? You know, property owners are using this property, so they would maintain it. I think the reason, what's the rationale for it? When you're maintaining property, sometimes when you're peeling back the siding or the interior wall or something like that, you may discover that you have some structural elements that have rotted over time. And so this code section then allows the property owner to go to the building official, say, has it reached the point where that structural member needs to be replaced? And if so, then the purpose was maintenance, now it's turned in, I need to replace the structural beam, the structural element. And what it does, I think the rational basis behind it is it prevents a person's maintenance activities from discouraging them to do that, because otherwise it might turn into a tear down. You know, if I start maintaining property and then find out it needs structural alteration, I would be running the risk that I might end up having to tear it down because I'd have to remove a structural alteration without the building official's determination. So that's why it's in there. Now, I will say that I think the applicant has stated, and correctly so, that what the applicant the activity that the applicant did, demolishing the building and then trying to reconstruct it, that is not maintenance. The applicant states on page 15 of their appeal statement that that's not maintenance, and we agree with that. And also, of course, it was not declared unsafe by the building official, so it doesn't. So the activity that is proposed or that's the subject of this doesn't come under the maintenance heading. So the next question is whether, okay, thank you, covered structural alteration. Structural alteration, that's just any one of those parts, and so you could have, when you're doing maintenance and you find out there's a rotted beam, you know, that sort of thing, so that's structural alteration. Okay, so now we come to the expansion or change section. So the code does authorize expansion of non-conforming structures and changes of non-conforming structures in limited matters. This is the exclusive matter in which non-conforming structures can be changed or expanded. As indicated by both the compliance section and the actual text of 5001-063 that says a non-conforming structure may only be expanded or changed in accordance with the following provisions. What are those provisions? You can expand a non-conforming structure under subsection 1 and 2. 1 is it can be expanded if it doesn't increase the degree of nonconformity and it doesn't create any new nonconformity. Okay? Typically that would happen, you have a non-conforming structure and you're going to do an addition into the conforming area of the property. Okay? So no setback intrusions or anything like that. So that's permissible for a non-conforming structure. And then under 2, go ahead. 2, portions of the non-conforming structure that are not being altered aren't required to be brought into compliance. So I'm working on the property, I'm working elsewhere on the structure, it's non-conforming, I don't have to bring the non-conforming part into compliance. That's what 2 says. Okay. 3, extensions, I can extend a non-conforming wall if approved through a minor variance. Well, yeah, I guess you could call it non-conforming, but I think of it as a minor variance section. So, and 4, and this is the specific issue which has been raised with some clarity by the applicant here, is for residential structures, a change in roof pitch on the non-conforming portion of the structure may be permitted if the roof height is not increased by greater than 6 feet and does not exceed the base zone height, okay? So what does that mean? Well, I guess I would say, first of all, when we're looking at the text and context of this, that doesn't tie to maintenance. That's not a maintenance issue. That I can, as a property owner, I could decide to change the roof pitch at any time. Okay, it can be a perfectly fine structure. Change the roof pitch. The question from a text, context, and legislative history point of view, and I think most particularly legislative history, is what did the Planning Commission and City Council mean when they said roof pitch? The applicant has basically said that if it's necessary to change the roof pitch, to demolish it and rebuild it in order to get my roof pitch changed, and that's what I get to do. We disagree. The legislative history, we think, shows that the pitch, you can change the pitch of the roof only. Okay? Under this section, your authorization is to change the roof pitch. Nothing about other structural members. Okay? I can change the roof pitch. I can change the roof. That's a structural alteration. This authorizes me in this limited provision to change the roof. Okay? If we look at the legislative history on pages 9 through 15 of the October 22 staff memo, went through and made some sections from the Planning Commission's hearing and submittals on pages, again, 9 through 15, that I think are most important to this case. I think the salient points are that you can change the pitch. That is not to be the commission authorized that, so it would not be an impediment to remodeling if the structure otherwise complies. That's found on page 12. The graphic on page 12 shows a change in roof, not a whole new structure. Most importantly, I think also on page 12, it says it encourages remodeling of existing structures rather than pushing owners into situations where they would tear down an existing building. The Planning Commission wanted to avoid that. That's why they allowed changes in roof pitch. I don't think they used, it's certainly no legislative history to suggest that was the tool to do that. Okay? The Planning Commission was asked in the context of Subsection 4, which we'll get to in a minute, but you've read, damage and reconstruction, as to whether or not a structure should be allowed to be reconstructed in the same non-conforming manner that it is demolished, either intentionally or by accident. Again, the Planning Commission was asked, should a property owner be able to demolish a building for whatever reason and then reconstruct it? And what the Planning Commission said was accidental, fire, et cetera, yes. Okay, you can reconstruct, you're burned out, you didn't plan on it. Okay, intentional, no. Okay, the Planning Commission said they did not authorize voluntary deconstruction and reconstruction of structures. Now, in fact, the Planning Commission removed the 50% test. It previously was if it had been damaged by less than 50%, you could reconstruct in the manner. They removed that. So I think the legislative history is pretty clear that what the Planning Commission and City Council as it adopted, it intended that the right to reconstruct residences was only then on the unintentional damage to property. Okay? It did not apply to intentional. And what the applicant, I think, is arguing is putting, well, it is not fulfilling what the commission would want, because it said, the commission said, we don't want you to reconstruct in a non-conforming manner when you're voluntarily taking action on the property. And if you interpret that under the roof pitch section, then you have not fulfilled what the commission wanted. The commission wanted no changes, no reconstruction. If it's going to be demolished, reconstruct in a conforming manner, except on the roof pitch, which we specifically authorized. Okay. The applicant's analysis seems to be arguing, I think, in two parts or in two alternatives. The first alternative is the roof pitch argument, and the second alternative is the code doesn't prohibit new construction and therefore doesn't expressly authorize it, so the applicant can do new construction in the same footprint as the demolished structure. So the applicant, I think, starts with the concept of I can change anything by justifying it under a roof pitch change, And if it requires a structural alteration of the roof, so be it. True, I mean, on the roof section, because that's it. To change the roof pitch, you have to change the roof, but it doesn't authorize any other structural alterations, because this is limited solely to roofs. It doesn't authorize supporting members, it doesn't authorize bearing walls, and those are issues that are about the maintenance section, and as the applicant has indicated, this is not a maintenance issue. So the applicant has said that all structural members can be removed down to the foundation and a new structure built to bring it up to current code under the roof pitch exception. Well, I think the legislative history is clear that that is not the case. The Planning Commission said you can change the pitch of the roof by elevating it, but it didn't say that you can do anything you need to. If in order to do that, you have to reconstruct the dwelling or reconstruct the structure, okay? Take out the bearing walls, take out the supporting beams, et cetera. That's not authorized in there, and I think you've now gone beyond the roof pitch change, and you would have to look for other authority, which isn't there. The Planning Commission didn't authorize that, or the City Council. The applicant has also cited subsection 4, and if you go ahead to 4, and that's the damage and reconstruction section. So that's so we've covered continuation, maintenance, expansion, change. Those are the changes. The only roof pitch is the only change authorized in subsection 3. So now we're at 4, which is damage and reconstruction. So if property has been damaged, then this section deals with whether you can reconstruct. Go ahead to the next one. Go ahead. Well, excuse me, go back one. Okay. So for this section, subsection 4I, the reconstruction of a non-conforming structure is exempt from the provisions of the code to the extent the damaged portion of the structure failed to conform when it's damaged by any cause other than an intentional act of the owner. Okay? That's what the applicant wants here. Okay? We need to reconstruct the structure to the same degree as authorized by the same degree as was occurred on the non-conforming structure. But the problem, of course, is it was the cause was an intentional act of the owner. Okay? Okay, next one. Subsection 4, which he asked for interpretation on, when all or any portion of non-conforming structure is damaged by an intentional act, then reconstruction shall conform to the code. Well, that's not what the applicant wants either, because the applicant doesn't want to reconstruct to conform to the code. Okay? So he's not arguing, they're not arguing a right to reconstruct under subsection 4 either, and believe me, it's clear to me from the issue was brought up in LUBA and the filings here. The applicant's not arguing a right to reconstruct under subsection 4 anyway, but I wanted to give the context here. Because what the applicant is doing, though, is pulling words from, I think, from the subsection 4 about reconstruction to comply with, to the same degree of the non-conforming structure. So I don't see, as I go through the code scheme here, I don't see any authority to do what the applicant wants to do, which essentially was 4A, that was when property is damaged by unintentional means, you can reconstruct. Okay? Intentional means they didn't authorize that. It's not under roof pitch either. It's not under expansion because they're not expanding. It's not under maintenance because they say they're not maintaining the property. I agree with that. And it's not under continuation. So I don't see any authority for that. So the alternative argument I think that the applicant is making is, they say on page 12 and 17 of their appeal statement, there is nothing in the code which prohibits or even regulates the action of rebuilding, demolishing in a new construction, the same structure with the same foundation, the same footprint, in the exact same dimensions. They also say on page 17, nothing in chapter 50 or non-conforming section 3 specifically prohibits an owner of a non-conforming structure from rebuilding that non-conforming structure in the same footprint at the same size and dimensions. However, the compliance section says you can't construct something that doesn't comply with the code. And so we're looking then in the non-conforming section as to, well, where's the authority? You know, I've just gone through it and said, there is no authority. The only change section that they had was to change the roof pitch, and the legislative history is clear that roof pitch does not mean you get to reconstruct everything under the roof, okay? So for the reasons, as I've just discussed here, we think that staff urges the interpretation of 2B, that's the maintenance section, and 3A4, the change of roof, as set forth in the October 22 memo. I will say, as I read Mr. Stamp's letter of October 29, on the question of our reply on issue 3, on whether it's no or yes, frankly, I had a little trouble understanding the question to know whether it's no or yes, but the text, I think, is clear. The question was, can the general conformance with the code provisions set forth in the compliance section be interpreted as authority to interpret code sections that authorize development actions as concluding an implied negative, i.e. an implied prohibition, with regard to potential development actions not mentioned in that provision? I have a problem authorizing development action as including implied prohibitions of the potential development. I'm not sure I follow all that. I mean, but as far as yes or no, but I will say that the compliance section of 50.01.02.2 prohibits any construction. It's not authorized by the code. Haven't found any code provisions that authorize what the demolition, the intentional demolition of a structure and then reconstructing it, not to conform to the code, but in the manner, what they want to do is in the manner which the non-conforming structure previously existed, which would be the case under subsection 4A(I), but that's only for unintentional damage. So I haven't found anything in the code that authorizes it. So that's why we think the interpretation as recommended is appropriate.
Okay. Commissioners, are there any questions? Craig? Bruce?
No.
Randy?
I did have some questions, if I could. And I understand we're here tonight because the applicant is requesting a formal code interpretation of the non-conforming structures ordinances. And so an initial question I have is, relates to the fact that from time to time we hear reference to DRC precedent on a matter. Some issue came before the commission a few years ago and the DRC made a decision about how code should apply, and then years later we hear, well, DRC precedent says X, Y, and Z. So I wonder, how does a formal code interpretation differ from what we typically hear referred to as DRC precedent?
Yeah, if I may. They're essentially the same thing, but they arise obviously in two different venues to you. If this was a minor application, and the question was, can we do this? You know, you'd be making the same question, same interpretation. What does the code say? Can you do it? A formal interpretation could be used and is used by applicants, prospective applicants, who want to know what the code says before they get too deep into it. You know, rather than doing all the plans in anticipation of what it would be. You know, so they might ask for a formal interpretation. Now, a formal interpretation, once issued, does bind the property. Okay, so it is binding. That interpretation is binding to the property for the proposed application. So now it's binding because notice has been, because it's about a specific piece of property, notice has been given within 300 feet. It is precedent, however. I think it does have life outside of the property because as the commission interprets this provisions, then staff will apply this interpretation to the other properties. In other words, we're not going to have a non-conforming interpretation A for property A and a different one for property B and a different one for C. So staff's going to apply that unless and until either the DRC comes up with a new interpretation type thing, or the city council overrules, comes up with this, or the change in code. Bottom line is, it has the same precedential value, I think, to staff and to applicants who are asking what the code allows.
And so they're given equal weight in future proceedings?
Yes, yeah, the only difference is, again, this binds this property, but for another applicant, it doesn't bind their property, but
And I think you alluded to it, and Planner Evans stated it, that our decision tonight then might impact how other accessory structures are treated in the future.
Well, it's going to impact any non-conforming structure, so any accessory structure or primary structure. So as the example was given, just as this could apply in this case to a very small shed located in a side yard, this could also apply if a property owner of a two-story house that's in the side yard, okay, that next to a one-story house, the two-story house wants to change the pitch of their roof, they want, okay, they can go up, type thing. So this would apply to all non-conforming structures, commercial, residential, of whatever nature. Okay.
Well, that's interesting. So, for example, in residential structures, something I've heard talk about is the difference between a remodel and a demolition of an existing structure to redevelop it, where there's some concept that if some element of the existing structure is retained, but most of it is eliminated and then rebuilt, that's a remodel that might be grandfathered in and allow some prior
well, again,
setbacks. So if we set a precedent here tonight, is that affecting dwellings too? Is that affecting the definition of remodel and demolition in that example?
I don't think so, because the question, I think the question here is, what is the scope of roof pitch? Okay? And I guess I want to correct myself. Roof pitch is only for residential, changes in roof pitch are only allowable for residential dwellings, so commercial property couldn't do it. But it would affect all residential buildings. That's accessory and primary. When you're looking at remodels, the question on a remodel would be, if it's non-conforming, is it for maintenance purposes? Could be, okay. Is it a change of roof pitch? Is it an expansion? I mean, you're still looking at those. If it's a non-conforming structure, you're still looking at that part. And then, of course, you're looking from an expansion point of view. Maybe you have a non-conforming structure and you're working in the conforming area. Okay, so that gives the authority to do that and not have to change the non-conforming section. So I hope I've answered your question.
So I was just interested in getting clarification on the facts of this matter. I think I understand them because of all the written material we've been provided, but just basically, this structure was built at some point, we don't know when, before 1984, and was non-conforming. And then in 2014, there was a residential infill design application, I guess. Would that go to the Planning Commission, or?
Well, I think it could go to staff, and if it was appealed. But, I mean, the facts of this situation are, I'm going to disagree. The facts of the situation are, we had a shed that was in the 60s, I think. And then the side yard setback came in, or the special street setback came in. That made it non-conforming, okay? So the question is, okay, so.
Mark? Dwight,
Thank you.
I have a couple questions. Craig, go ahead.
Yeah, well, I know if you want, I'll just jump in here quick, now that our commissioner set the stage with the legal knowledge. The precedent issue is, somewhat concerning to me because we have a lot of developers come up and we give variances, setbacks that we're create a condition for that they can have a variance. So how does that relate to, you're saying this is different in that because this accessory structure, and it's not just whether it's a setback or anything like that, we have all sorts of variances that we've had come in front of us. Why would this precedent set any precedent for anyone else but others don't?
No, maybe I understand your question. when you decide to grant a variance, when you're hearing an application for a variance, you know, the question is, does that set a precedent? Right? The answer is typically, and no, because the facts, the circumstances of the property and its relationship to other property is unique. Okay? Whether there's a retaining wall, whether there's landscaping, I mean, what kind of mitigation people are going to do. When you're looking at a variance, those are unique circumstances. None of them would be identical. If they were identical, then yeah, I'd be arguing that there's some precedence there. Okay? If they were identical. What I'm saying from a precedential nature of this application, is the circumstances of the surrounding property are irrelevant, okay, to this. The question is this a non-conforming structure? What has the applicant done to it? You know, do they propose to change the roof pitch, and if so, can they then demolish it? I mean, that has nothing to do with any of the circumstances that you would typically consider for conditional use, variance, RID, et cetera.
Thank you.
Go ahead, Mark. Sorry, following your line of reasoning, I'm struggling with understanding why on two separate occasions building permits were granted to two different property owners. And my understanding, having read through this, and maybe I got this wrong, but was that the building permits dictated that with the change in roof pitch that somehow required, I don't know about this, but it somehow required work to be done on the foundation. So if the building permit was granted by the city, A, why didn't they take into consideration the line of reasoning that you've presented so eloquently? And then B, if the building permit said that the building basically had to be taken off, fix the foundation, and then reconstructed, why isn't that okay?
Well, I guess I would say, first of all, when the building permit was, well, when the RID was approved, okay, but the RID said there's no variances we're getting to the accessory structure. All you can do is change the roof pitch, okay? So then the building permit comes in for the house, the carport, and it includes the accessory structure. And I would say, as we have said, that the building permit was issued in error. Okay? That as to the accessory structure, it should not have been issued. Okay? But I think because it was a small part of it, when you look at the plans on it, it's, I don't know, Brian, do you have any comment on it?
The second time it was issued is the question?
Yeah.
Yeah, a staff member was trying to help a customer, new customer, obviously, and issued the permit, made them reapply for it, and issued the permit.
But if the permit was issued by the city, and then the applicant acted in good faith, presumably, on the granting of that permit, why then is the applicant being stopped dead in their tracks and being essentially held accountable for an error that was created by the city? That's my real question.
Well, Commissioner Silent, what I would point out is that is being adjudicated, that is being taken care of. There's a tort claim that they filed. And
I'm aware of that.
You are not here to resolve that issue. All you're here to look at is how we interpret the code with regard to the non-conforming structure. That is the only question that is relevant here tonight.
And so the
That
question
other
is,
information is good for background, but it is not relevant to the code interpretation before you.
and so the question to Mr. Silent's hypothetical then, or the question is, was the building permit valid, correctly issued? Did it correctly apply the code, or did it incorrectly apply the code? That's
Correct.
That's the question.
That's another way to phrase it.
Okay, and when the building, in the RID approval, it didn't say you get to tear down the structure. It said you change the roof pitch. That's all the RID approval said, okay? So then the building permit comes in, and it shows a removal. There is no analysis We don't get this analysis here. It was issued, and I think in error. Okay? And then when the second building permit came in, it was just a reissuance of it, and so there really wasn't any analysis. And so the first building permit issued an error relative to the accessory structure. Second building permit was issued with it was just reissued. That's all it was. Okay? With perpetuating the same mistake. Okay.
Thank you.
Okay. But again, I just want to emphasize, to me, the building permit history is irrelevant. And I know the applicant's going to bring all this forward because it's great sympathy, okay? But the question to the commission is, if they had asked what's the analysis on the non-conforming structure, or when somebody else comes in to the desk, what's our analysis? That's the question to the commission. It isn't unique to this applicant, or it isn't based upon the circumstances that bring them here. I mean, if they have suffered hardship, have suffered a loss, a damage, then the way you take care of that is through the tort claim they filed. Okay, it is not, and in some cases, I mean, if the city makes an error, okay, it doesn't just say, well, keep the house, no problem, because it impacts the neighbors around. They were not involved. Now, I know in this case, I think the neighbor's going to say, I don't have a problem with it because it's a small shed, okay? All right. But your interpretation applies to all types of structures, okay? And it could be applied to complaining neighbors. And the remedy is not to say, we're not going to apply the code. The remedy is to apply the code, and we've had these cases. Sometimes a building permit is issued in error, and in that case, then if there's liability, then the city pays, okay? But that's the remedy, not to modify the code, or not to balance your code interpretations based upon the circumstances of the applicant, okay? Because it applies to all applicants.
Anybody else? Okay, I've got a couple. You mentioned something just in this last explanation, and it jogged what I was thinking the whole time. So I've got a shed, all right? A building, non-conforming. I bring it in and I want to fix it up, and I want a building permit. Who has to go through and determine it's conforming or non-conforming? Is that the city? Is that my architect? Who does that?
The application is filed with the building department. It is reviewed by the planning department, okay? And then they would sign off on it.
Okay.
Now, I also want to say, as the city...
That kind of answers my question.
Well, I have to say, though, the obligation to comply with the code, okay, is ultimately the property owners. Okay?
I understand.
It is not for, I say this, I mean, this arises sometimes, it is not for the building department to catch you, okay? I mean, you have to comply with the code. If they miss it, that doesn't mean it's all legal, okay?
Yeah.
And in some cases, we end up revoking or suspending a building permit to do a stop work in order to do correction, okay? Because they missed it, okay?
Yeah.
But ultimately, the obligation to all code provisions is the applicant to comply with the code.
Okay. So, would they have been able to rebuild the shed exactly how it is? If they could just come in and said, we got to fix this thing up, we're putting the walls and the roof right back the way it is. They could have done that. Well, they could have taken one wall off at a time, so it was a remodel. There'd be a way to do that.
Yeah, no, there's not. See, again, there's no 50% test anymore, so you can't do progressive remodeling. Okay. So you'd have to. The question is, did you intend to remove it? Okay, and if so, for what purpose? I mean, if you've removed it for maintenance purposes, okay, because you think I want to fix it up, and then you find a structural member is a problem, then you can fix it if the building official agrees that there's a structural problem.
All right.
Okay,
And the building official never was there.
that's correct.
Okay, so the one thing in all your narrative that leaves me, and I thought about this when I read it, can you go back to the 6-foot roof pitch on the, so if I've got a structure, non-conforming, and I want to raise the pitch of the house 6 feet, and it's not going to break any other code height limitations. This is what I have to work with. This is the governing paragraph.
That's right.
I don't go into the history of the planning commission nor what anybody was thinking. I look at this and it says, does not exceed the base code. It said the height not increased by more than 6 feet.
Right.
All right. So if I've got a building, it's not conforming, and I want to take it up 6 feet, that says I can do it. And if I have to put new columns and posts in, I don't know where that precludes me from doing it. I mean, just in the statement that you can take it up 6 feet, you know, you've got to change the support system to be able to do that.
So maybe I can help understand.
Unless you're trying to tell me the intent of this is to use what's existing.
It is, yeah, so.
But we don't rule on intent, we rule on what it says.
Yeah, so code allows you to change the pitch of a roof. So you go from a gable roof to a shed roof. You can't increase the wall height, you just change the roof pitch, that's it. So you can put up new supporting structures off the old ones, but you can't tear down the structure just to change the pitch of the roof.
Where does it say that?
Well, under these different code sections, so.
No, give me the one where it says change the roof pitch 6 feet. That's the one I want to see.
Well, you do look at legislative history to determine what change of roof pitch means.
Well, it says right here, you can move it 6 feet.
So it's just the roof.
Okay, so if
you
my
want to do
understanding
structure-
is you can change the roof pitch a lot of different ways.
That's right.
I mean, so what I don't understand is how you're telling me that I can't raise the roof 6 feet, and in doing that, and we have a structural engineer here, we have an engineer here, that I don't know of many roofs that you can increase the height by 6 feet and not have to change the structural underneath it. I mean, I'll be honest with you, I can't think of how that would work. Unless you've got an existing big concrete wall and that you just want to go up 6 feet, and if this is what you have to go by, you know, I don't understand. That's the one thing in your whole statement, Evan, I can't get my head around. How this prevents someone from changing the structural underneath it.
Well, I look at what, when the planning commission and city council adopted this, what were they authorizing?
No, if I'm a homeowner, that's not what I go back and look at. I look at this.
Well, but if my question is, what does change of roof pitch mean? What is the scope of modifications I can make under a change of roof pitch? I can change, there are different ways to change the roof pitch. It all doesn't require demolishing the structure.
No, this was a complete demolition. They didn't need to do that.
Okay, I understand what you're saying, Brian. I appreciate that. What I'm saying is, regardless of what happened on the structure, I'm saying I'm looking at right here what it states, and I can't understand where that precludes me on my shed, on my house. I have an outbuilding, and I want to take it up, which I don't, but I mean, if I did, I want to take it up 6 feet. It doesn't say I can't improve the structure underneath it. It just doesn't say that. It says you can do this, but it doesn't say you can't strengthen the walls underneath it. It doesn't say that.
Well, when you start removing structural members, and in this case, demolishing the structure in order to do it, I think you've gone outside the scope. You can improve it.
Well, this implies that you can do it, and if you're, I mean, you've got a building official here and you've got an engineer here that's saying you can do this. I mean, if you're going to take it up, then it should have said you can do this, but you can't alter the existing structure. Doesn't say that. So my interpretation would be I could take it up and I have to support it.
Well, if you
Either existing walls or new structural members.
I mean, this authorizes a change in the non-conforming structure. A change.
So walk me through how it doesn't. That's, I guess my question is, that I couldn't quite understand, is tell me why this precludes it. I know they tore the building down, that's different. I'm saying, if I have something, I want to take it up 6 feet, why can't I support it?
Why can't you support it?
Yeah.
Yeah, I think you can support it. Can you demolish it? No.
That's a different question.
Okay.
I'm saying, you're saying, what I want to understand is if I can take it up 6 feet, can I structurally support it? Can I add structure to support it?
As part of the roof, you can do that, but you can't remove the supporting membrane underneath it to do so, unless it's normal maintenance and repair, or the building official determines it's unsafe.
What do you mean membrane? You talking about the roof? You talking about what?
Talk about the frame, the columns, any structural support for the roof underneath it has to remain. But you can change the roof.
Okay, so I change the roof so I can support it.
Okay, what does that mean? What are you talking about?
I don't know. It just says you can raise it 6 feet, so I'm saying I can support it, because you're saying I can take it up 6 feet,
Okay.
right?
I don't understand what you mean by, can you be more specific?
How does one support it?
Yeah, what do you
Maybe
mean by
that's-
support?
I mean-
Talking about a different
Well,
part of the roof?
If you can take it up 6 feet,
Yes,
just in that statement, not increase by more than 6 feet. So that means you can take it up 6 feet,
that's right.
right?
Yes,
So that implies that you can hold it up.
that's right.
So that implies that if you've got a structure that is non-conformance, if I have to add new members to support that roof, that would be allowed.
Yeah, you can,
Yes, but you could do that without adding members too. You can get a truss design without adding members to that roof system. You can get a truss that is higher pitch without adding extra support and do it. Now, in this case,
Not this case, in all cases, because this is what we're setting down.
I understand.
I disagree with that. If we're gonna raise this roof 6 feet, you're gonna say you're gonna change the truss and
no,
carry the.
you can order a different truss pitch. You could have lower trusses and you can order higher trusses, and they're still the same bearing. Now, there are situations where you can raise the roof and you have to add extra support members, but you're not demoing the entire wall system of the house
Okay.
or of the structure.
yeah, and I think that, but this says change the non-conforming structure. And I think that's the limit of it. You can change the roof pitch, and if you have to support it, okay, but that doesn't, and you can add members to do that, but it doesn't mean demolish the structure and rebuild it. Okay, that's where the city, that's where we leave the applicant. Because that's addressed under the damage section, and that's only for unintentional. This was not an end around by saying, you know, I want to change my structure, my non-conforming structure, I want to redo the whole thing. I'll keep it in the same footprint, but I want a completely new house. So in order to do that, I'll change the roof pitch. Okay? That's not it's not a vehicle to demolish and reconstruct structures. It's a vehicle to change existing structures, roof pitches, and if they need to support the beams, you know, fine. But I think that the demolition takes it beyond.
Okay. Anybody else? Okay. Go ahead, Craig.
What is the square footage of this again? It was
165.
165?
Square feet.
But again, of course, this could apply to a 4,000 square foot house. Okay.
Okay. Thank you. Now we'll hear from the applicant, just a second.
Oh, hey, can I, there is, Evan, there's one document in there that I realize is new. And that's the,
Yeah, go ahead and ask Jason. I think that's appropriate as chair.
Let's come up here.
Do you want me to?
Yeah. What's the protocol for masks when we're talking?
Hang on a second. Okay. I'm sorry, your,
My name's Andrew Stamp. I'm a land use attorney in Lake Oswego. My address for the record is 4248 Gilwood Street, Lake Oswego, Oregon, 97035. And my question was, do you want me to leave my mask on when I talk, or can I pull it down?
Jessica, that might be.
Okay.
I
You
have a
require a
question.
mask, so you should wear it properly.
I have a question for you.
Yes, sir.
You have 20 minutes, and we kind of went on a long time.
Right. I was going to
that-
ask if you'd indulge us to at least have 30 minutes, because the staff report was 33, not including questions, and it was an hour including questions.
Well, the questions don't count.
I know.
So I was going to say, can you put it on in 20 minutes, or let's see where you're at. And
Okay.
we'll be lenient with the time.
Okay, thank you, sir. I really
Okay.
appreciate it.
We want to be fair.
As I said, I'm here with my client here tonight, Vanessa Coughlin, who's right here. I'm also here, she's a disabled U.S. Army veteran with 18 and a half years of service. I'm also here with Stephen Winstead of Building Forensic. Steve's a former building official. We met in 2004 when he was the building official for the Tillamook County. And he currently serves as an architect and consultant, and he's also been a planning director as well, right, or a planner?
That's correct, yeah.
That's right. Ms. Molkoffen is an Oregon native who wanted to live on the lake, and she finally was able to buy the smallest parcel with lakefront access. It's a tiny 1,000 square foot home, but it is on the lake and it has a deck, and she was excited about moving here. She has a son who's disabled and sometimes has to use a wheelchair. His name's Peyton. And she was thinking that the accessory building would be a good place for him to stay because he has sometimes trouble with stairs. So I'm gonna, let's see, hopefully I can do this slide. Just real briefly, we can see, I don't know when that picture was taken on the left, but it's pre-time when Vanessa owned it. And you can see the current building right there. I tried to take that picture as with, the same perspective. One of the things I point out is there's arborvitae that's grown here that now you can see. It used to be the other house next door really shone down on the Vanessa's house, but now the neighbors put up that arborvitae, and it works really well for both neighbors. So you have at least a number of letters from neighbors in the record. There should be 3 if they all sent them. I've seen drafts, but I'm not sure if they all made it in the record. But one common theme in the letters is that all the neighbors agree that the Coffins have greatly improved the property. And one of the things that's frustrating for the Coffins is here, we took all the risk to rebuild this building in a way that is attractive. And now the city seems to be punishing them because of a mistake that the city made. And, I think one of the policy points that the commission needs to think about is, what kind of city do you want to be known as? Do you want to be the city that just pounds on people when a mistake gets made, you're going to take away their rights? Because really what staff's saying is, sorry, we messed up, but, too bad, so sad, it's not our problem, it's your problem. And we really think that's a bad approach, and the DRC should really think about not adopting that approach. This case is about this accessory structure. It's small, it's 165 square feet. It did have a bed, a sink, a toilet, and a shower. People lived in it. It was used for foster care. Kids lived in it. I think I was told that one of the original owners lived in the accessory building when she got too old to use the stairs. Staff wants that building gone. Apparently, it's really upsetting staff. They've spent over 100 pages of legal writing to try to get rid of it. And really what they're saying is, you followed your building permit, but what you didn't know is that it was based on an expired writ, and therefore now you lost your rights. Now, one of the issues that's come up is precedent. And this is going off script a little bit, but what I'd say is, if you want to help Ms. Coffin out, you can do it without broad precedent, because one of the issues in this case is the roof pitch issue. And what we're saying is that if you get land use approval to change the roof pitch, which is allowed by code, you also get the corresponding right under the building code to do whatever building code changes you need to effectuate that change. That's not a very shocking or drastic code interpretation. It takes care of Ms. Coffin's case for sure, and it doesn't serve as broad precedent outside of that context. But what you heard staff say was, oh yeah, sure, you can add supporting members to it, okay? But what my building official here is gonna tell you is that no, you can't just stop there, because once you add supporting members, you also have to change the foundation. And in this particular case, when you have a foundation that was laid in 1960, it's not gonna meet seismic code. So you're gonna have to upgrade to modern seismic. So there's sort of cascading effect of secondary effects, if you will, that happen, and the snowball starts going downhill. None of which was considered by the city planning staff, because frankly, they don't understand a damn thing about the building code. You saw that right here as they were standing in front of you. So, so that issue of precedent, don't let it affect you. I think you can do what's right for Ms. Coffin tonight, or if we keep the record open whenever the time comes. But you don't need to worry about broad precedent. I can certainly write the findings in a way that makes the precedent as minor as can be. Let's talk briefly about the timeline of key dates, because it's really important in this case to understand the facts of the case. What you had is in December 8th, 2014, the prior owner submits a writ application, and he wanted to change a lot of things both on the main structure and on the accessory building. That was approved in March of 18, but the staff said, we're not gonna let you change the accessory building the way you want to, because you wanted to raise it up to 2 stories, and we're not going to let you do that. But we will let you, if you want, change the roof pitch. Okay, so he did that. He left it 1 story, but he came in with a roof pitch change in 2016, which is, that permit was approved in 2017. Now, staff says that that permit was issued in error. It was not. It was issued in accordance with the law, okay? Now, assuming, of course, that your interpretation is if you can change the roof pitch, you can also make the corresponding changes to the building code, which is the current law. Now, that, unfortunately, Mr. Masters didn't do anything with the structure. You know, he didn't implement the writ, and he didn't change the accessory structure. He just decided to sell it. The writ expired April 2, 2018. Before that, before the writ expired, Ms. Mulcoffin was in negotiations to buy it. She was told by him, yeah, I've got permits to rebuild it. All I got to do is go down there and, you know, pull a new building permit. And she's like, oh, great. And so she buys it on May 24th or May 25th, 2018, somewhere in that time frame. But by then the writ had already expired, unbeknownst to anybody. Well, she was still on active duty at the time, so it wasn't like she could just come down to the planning department and check. But she did her due diligence, and they had told her, that the city had told her the same thing. Now, in 2019, she's off active duty, she's ready to start, and she goes down to the city to get that second building permit. She didn't bring plans with her because she didn't have any. She said, hey, you know, city, can you dig up those old plans? And the city's like, oh, sure, no problem. and she gets the plans, and they stamp them, she pays her fees, and off she goes. In February 2020, she builds the accessory structure, rebuilds it, takes it down to the foundation. She didn't get rid of the foundation, but she had to add to the foundation to bring it up to current seismic code. So she had to fix it basically and make it better. They issued a stop work order a month later. Then we have this, what I call the unnecessary procedural wrangling. I wanted a hearing in May of 2020 in front of this body, but the city says you can't have a hearing. And I said, well, I'll see if LUBA will agree with you or not. So I appealed the stop work order as a land use decision. It most obviously was a land use decision if you read it, because A, it applies the code, 2, in a manner which is intended to be binding on the applicant. Well, that's all it takes to be a land use decision. So it was a land use decision. And we briefed it. We spent a lot of money and a lot of time briefing it. By August of 2020, I think the city realized it was going to lose at LUBA, so they said, all right, let's take it back. You agree to submit a land use application, we'll agree to hear it. And I said, okay, thank you. Here we are tonight, 18 months later. Now, interestingly enough, we are asking for a development permit. The city blew the 120-day rule, so now if I want, I can forum shop this case. So if I don't like the answer I get here tonight, I could go to Clackamas County Circuit Court. That's what the law says. So, RID application, you can see the 2014 right here, the 2-story, the 2017 building permit. Now, one of the things you notice is that there was this big glulam beam for the carport that was actually attached to the shed. That's one of the reasons the building permit says that, that the whole shed needs to be taken down. But it would have been been taken down no matter what, anyway. So I'm going to, in the interest of time, I'm going to fast forward to this slide right here. This is the 2017 building permit. What you see, read that note very carefully, garage to ADU, scope of work. Garage foundation and slab to remain. Garage walls have to be rebuilt due to new roof structure. Okay, so what does that mean? Well, that means the building permit required her to remove, to take down the whole thing. And if there's any doubt in there, this says new wall. Oh, look at that. The whole darn thing is shaded, including the interior walls. So the building, so the city says, just now in front of you, they said, wow, the building permit was issued in error. Well, obviously someone in the building permit department didn't think it was, Mr. Dom didn't think it was issued in error because they signed off on it. So going back, this is really the heart of this case, and Chair Sherry, you really hit on this with your testimony. It was very astute of you. I appreciate it. But this is the key. You got a gable roof from a building that was built, as Evan said, in probably 1960. I don't know the exact date. But you've got existing walls that are, say, 8 feet tall. With a shed design, you got now a 12-foot wall. Okay? You can't anchor a 12-foot wall in the same manner as you do an 8-foot wall, particularly if the foundation's 60 years old. Okay? It's just not how it works. And this is the thing that neither one of the two gentlemen who are sitting here understands, is that the building department doesn't care what land use says. They've got building code they need to implement. And the building code says modern seismic code demands upgrades to the foundation once weight-bearing walls are replaced or upgraded. The other thing to consider is that with the gable roof, you have trusses that support the roof. With a shed roof, the walls support the roof. So you got a lot more pressure right at that point right there. So you had to do seismic upgrades, new footings, larger stem walls, and anchor bolts. Now, let's go back to the RID. Here's the findings. The change in siding materials is permitted because it would not increase the degree of nonconformity. Okay, well that's completely different than what staff said tonight. Staff said you can't do any changes unless they're specifically called out in the code. Well, there's nothing in the code that calls out changes in siding materials. And he says, well, that's maintenance, right? Well, no, it's not, because it's not necessary to keep the building in safe condition. All right, if you change from stone to wood, that's a change, it's not maintenance. Now, there's the second thing where, right here, the second point, the city said, we're not gonna let you do that 2-story roof because you're only allowed to do a change in roof pitch. But we'll give you three options. Here's the 3 options. Look at number 3. This is the one that the landowner ended up doing. Modify the roof pitch starting from the existing top wall plate to create a shed-style roof with a maximum overheight of 13 feet that slopes down towards the abutting property towards the southwest, and that compliance with this section will be assured at the time of building permit application. That's what happened. The building department said, yes, you do need to take down the entire structure all the way down to the foundation. That's obvious. That's what the building code requires. To that last slide? Yes, sir. There's 3 options there. There's not a whole lot of difference between number 2 and number 3 other than the change in the roof. It says reduce the pitch of the roof or change the roof to a shed. I mean, that's the only difference between 2 and 3. Let me know when you're finished, sir. Okay, thank you, sir. So important takeaway from the facts. City planner offered the change from the gable roof to a shed roof. And then once that happened, that kicked into motion the building code because the building department requires compliance with the current building code, which requires that building be rebuilt from the foundation up in order to effectuate the shed roof design. You had a bunch of things that had to happen here. The support wall had to be replaced. The entire foundation needed upgrades. You had a D1 seismic category that requires new footings. You need new stem walls. You need continuous foundation all the way around instead of the way that thing had been built in 1960 where there was really not much building code, if any. And then it needed new anchor bolts. So there's a lot of things that needed to happen. I've already gone over that. All right, so here's the 2 staff themes of the case. Staff theme number 1 is landlord loses rights to non-conforming structure when staff makes an error. And what you saw here tonight was the building staff did not understand the building codes and consequences of land use planning decisions and action. The building department's not talking to the planning department. And then the second is building department mistakenly issued the 2019 building permit based on the expired RID. Now, the 2017, it was fine. It was done according to law. But that RID, you heard Evan say it, the city was negligent. There is a tort in Oregon, negligent issuance of building permits. I mean, prima facie case just here made tonight, just on the basis of admission. So the other staff theme, no right to reconstruct, replace a non-conforming structure. Here's what staff says. This is a key quote. When a building reaches the end of its life, the non-conforming use section of the zone, and I said zoning code, I know you guys called it community development code, but zoning code shorter, does not allow new structures to rise from the debris of the removed non-conforming structure to perpetuate the non-conformity for time eternal. Well, that sounds real poetic, but let's talk about what the code really says. And if you were trying to effectuate that policy position that's up there in blue or purple or whatever that color is, I'm colorblind too, whatever that color is, if you were trying to effectuate that to get rid of non-conforming uses, then why would you put this in your code? Damage does not include dismantling of a building or site feature or portion of a building or site feature in the course of voluntary reconstruction or repairs. Notice, of course, that Evan did not cite, he skipped right over this provision of the code. He didn't let you know about it. Why? Because it's a killer for him. He blew right through it. Never even mentioned it. Damage does not include dismantling of a building. And notice that it's the entire building, not a portion of building, because it calls out portion of building separately in the course of voluntary reconstruction. Well, okay, so you got to think about this. Why would anyone put that in the code if they wanted to get rid of non-conforming uses? They're basically saying you can rebuild them. Well, isn't that the big mystery of the evening? All right, next one. Here's another one. This is just mind-boggling. Maintenance does not include a structural alteration unless structural alteration is required to remedy a condition declared to be unsafe by the building official. Okay, well, if you're trying to not let new structures rise from the debris and you're not trying to perpetuate them for time eternal, why would you let, if the landowner lets his building become unsafe just because he didn't take care of it, why would you help him out? You wouldn't. You'd say, you know what, you lost your rights, sorry. So that second theme has nothing to do with reality. It has nothing to do with your code. It's a pure invention of staff. And the third thing, the code even allows non-conforming structures to be expanded. Well, why, if you're trying to get rid of them, why would you let people expand them? That's what, dump more money into it? Are you kidding me? No, that's not what the code says. So here's my three themes. The city erred, the city needs to take responsibility to make it right. Secondly, the code allows a change in roof pitch, which also encompasses all of the building code requirements upgrade need to effectuate that change. And three, nothing in the code prohibits changes which do not increase the degree of nonconformity, including the voluntary reconstruction of a nonconforming use. Now, I don't necessarily need you, if you're worried about precedent, I don't need you to rule on this. These are two alternative suggestions. 2 and 3 are alternatives. This one is the more narrow one. This is the one you can tackle if you want to, but as long as I get this one, I'm okay. Or my client's okay. I've been living this so long, it's starting to feel like mine, but but anyway, that's the key there. Is all we're asking for is to say, if the code says you can change the roof pitch, then you also get to do whatever it takes under the building code to make that happen. Now, I got my building official here. He'll talk about this in more detail, but the important takeaway is you can't raise a structure up 6 feet. And I think Chair Scher identified this correctly. You can't bring it up 6 feet without having a whole bunch of secondary building code effects, cascading effects, I call them, because one leads to the other. Once you start fiddling with one thing, you start having to fiddle with a whole lot of things. And unless that structure is really new and it's built to a really high code standard, then you're not going to be able to do it. Particularly in a 1960 structure or 1970, whenever it was built, you're not going to be able to deal with that. Now, I'm going to skip over the basic structure of the code because I think we've talked about it. Here's the definition of maintenance.
We just, minutes.
Thank you, sir. I really appreciate it. All I want to say here, because I know we've covered a lot of this ground, the code defines the term maintenance, and staff correctly said that it doesn't include structural alterations unless the building official says that your building's unsafe. That's true. We could have made that finding had we been asked to do so. All the evidence in the record is that the building was falling down. It was in poor shape. We have the neighbors saying that. We have Ms. Coffin saying that in sworn affidavits that I presented to LUBA, in fact. So, and there's no evidence to the contrary. But we were never given that opportunity because we had a building permit that we were working off of. All right, the other thing to think about here is the definition of necessary. It's very narrow. It's that cannot be done without. It's mandatory. That is a limiting term because it's not upkeep or repair that will make your property prettier. It's necessary to keep it safe, in good and safe condition. That's a very narrow set of circumstances. Changes. Now, what staff says is this beginning language up here, non-conforming structure may only be expanded or changed in accordance with provisions of this subsection. And he says, well, you just read down there, and if you don't see it, that's something that gives you the right to do it, then you can't do it. That's not how the code's written. You don't read it in terms of what it allows you to do. It's what are the limits? What are the prohibitions? Your code says you can't occupy your code unless it's in compliance with this code. Well, let me ask you, how many of you guys are pet owners? How many of you own dogs? Okay, where does it say in the code that you can have a pet hermit crab? Okay, or a dog? Well, you're gonna look through the code. No, it doesn't say it anywhere. Well, I guess you can't have dogs, right? Can't occupy it unless it's in conformance to the code. The code doesn't say boo about owning a dog. You're like, wait a minute, we don't regulate dogs. Aha, you're right, you don't regulate dogs. That's the key, is you look at this in terms of prohibitions, not in terms of what it says below. Now, if you want to find legislative intent, you look at it from right there. It says, non-conforming structures may only be expanded if you don't increase the degree of the non-conformity. What I'm saying is, if it allow you to do expansions, then why wouldn't it let you do a change that doesn't increase the degree of the non-conformity? That's the same thing, except it's less intense. So there's your legislative intent right there. They're setting the limits on what you can do. They're saying you cannot increase the degree of nonconformity, which of course makes sense. If you got a 20-foot setback, you're 10 foot into it, you can't go 5 feet. All right, I'm gonna burn through this real quick. Damage, there's the definition of damage right there. This is what Evan didn't point out to you. Damage does not include dismantling of a building in the course of voluntary reconstruction or repairs. He never assigns any meaning to that. And as far as I can tell, under his worldview, there is none. So with the remainder of my time, I'm going to let Steve Winstead talk, because I want to make sure his points are well understood. Thank you for your time.
Yeah, my name is Steve Winstead. I live at 7197 Southwest Lake Bluff Court, Wilsonville, Oregon. Retired building official, architect. I've been a planner and planning director, so I totally understand a lot of what's being said here tonight. But I think the thing that I really want to focus on is two things. One was that section 5001-006 that talked about the 6 foot. To me, that's a very ambiguous statement. And the reason why it is because it doesn't take in consideration the ramifications. So I take my planning hat off and put my building official hat on and say, look, if I'm going to go 6 feet more in height, all my walls are higher, I have more wind exposure, I have more lateral analysis that have to be done, I have to look at the foundation to make sure it can support, and now what would be a 12-foot high wall, my studs may not be the right size and the spacing because of the height. There's all kinds of things that happen with that simple statement of 6 feet. And I think that's where the crux is here. It's been said that a lot of things were done intentionally. When the building department says to you, I'm sorry, but that foundation you have is not going to support the lateral forces. You're going to have to do something with it. Or that stud wall isn't right. Or the nailing on the plywood. Or the shear panel that's being constructed. Those were all building code issues. But the bottom line is it gets back to this same thing that's been stated. This 6 foot pitch. That 6 foot pitch caused, and I'm retired military also, we call this a mission creep. What we wanted to do at one time began to expand and expand and expand. And that's what happened. So this mission creep was just going to be this, now ended up having more things added onto it as a direct result. I think that one of the things that I would say here also is that there was what I would say, an escalation of building code requirements that were not really thought about when this, not only when it was approved, the LU 14 way back when, but also the impact of what it was going to do on the project. I want to give the building department a commendation here though, because I think that they really went out of the way to help our client. They did everything they could to help move this project along until they found out there was an issue. And that's when they put the stop work order on it. They had inspections, they had consultation, they had people out there, building inspectors out there, talking to them. Everything seemed to be going in the right direction until we found out that the land use folks did not want this to continue and they had to issue a stop work order on it. But getting back to the main argument here at this point, I think it was very, very clear, dealing with that section on the 6 feet. Also, there was another section talking about unsafe. The unsafe condition shall be deemed to be created if, in addition or alteration, causes existing building or structure become overloaded or unsafe. This now became an unsafe building by the fact that the city allowed or permitted 6-foot-high additional height. It actually exasperated the condition. So I hope you understand what I'm saying on this thing, because I think that it became a snowball effect. It really did. And if there's anything that could be looked at, is maybe you look at how you write that 6-foot pitch and talk about that pitch being as reflective in terms of all the other building code ramifications that go with it. Matter of fact, also in the approval, it says that compliance with the provisions of this section will be assured at the time the building permit application. And so it's the baton being passed off to the building department from the planning side. It's okay to do this, but by the way, you gotta have it assured by the building department. Okay, so the baton's being passed, the building department says, yep, this is what we're gonna do, we're gonna issue the permit, these are all things you have to do. I can go on about building code, but I think that at this point in time, it is not gonna be any helpful to us. We've already kind of talked about it. We talked about lateral forces, we talked about footing size. I can cite the code right and left, all the different violations that occurred. I'm not here to do that. What I'm here to basically is to ask you to really consider this application. I don't believe you're going to be setting precedent, because you got a one shot, one time, this is the site, and these are all the ramifications that deal with this one site. And with that, I'll entertain any questions.
So let me skip to the last slide. I've got a bunch more here. I could have gone into a lot of detail, but I won't. Let's just talk about the bottom line here. The DRC can find that the non-conforming structure section of the code does not prohibit a landowner from reconstruction of non-conforming structure pursuant to a building permit when the landowner does not propose to increase the degree of non-conforming, including voluntary reconstruction of the non-conforming structure. That's the broader interpretation you can adopt tonight. That would have a little bit more precedent, but it's still not earth-shattering. It's consistent with the idea that you can do whatever you want to your structure as long as you don't increase the degree of nonconformity. So that's completely consistent with your code. The second thing, the more narrow basis for ruling in our favor is to say that the code allows a change in roof pitch, but that if you propose a change in roof pitch up to 6 feet, that also encompasses all of the building code requirements upgraded needed to effectuate that change. That's a very narrow ruling. It just says, you know, the building code is going to have some secondary effects, and you're allowed to do that. I think that's the current state of the law, okay? Because the building code is what it is. It's a separate breathing document aside from land use. And once you say something is allowed in land use, then you hop over to the building department and they figure out how to implement that land use approval. And they say, okay, you got the land use approval, you can go up 6 feet. Okay, what does that mean in terms of, well, your existing structure is kind of horrible. You're gonna have to do a lot of work to do that, but planning says, okay, you can bring it up. What planning's saying now is the building permit, the building department has to then say, you can only change your roof pitch if it doesn't have any secondary building code effects. And that's a very narrow set of circumstances. I would say it's almost never gonna be able to do anything. It almost nullifies the entire roof pitch change. And you've asked me to wrap it up, and so I will. I also have my client here if you'd like to hear from Ms. Coffin. I think we've given you a very clear presentation of what the issues are, and I'm hoping that you will rule in our favor. If you do want to hear from Ms. Coffin, she's here to testify tonight if you'll accept her testimony.
Okay, any questions from the commission? Mr. Barati.
I'm sorry, sir, I can't hear you.
If we hear from her, this would be her question. what is the intent of the property, of that building?
I can answer that for you.
Okay.
She would like her son to be able to have his bedroom in there, kind of, it's perfect for a teenager. You can turn the music on a little louder and not the rest of people in the rest of the house, you don't have to hear it. It's not gonna have a kitchen in it, but it has a shower and a bathroom.
Okay, it's occupation, it's gonna be occupied.
It's gonna be occupied and it will require building permits. I mean, we're not trying to get out of the building permit. It is built to code right now.
Bruce? Randy?
I just wanted to clarify, and thank you for the forceful and persuasive presentation, but I wanted to clarify, is it part of your contention the city has stopped from withdrawing the permit approval by...
I hate estoppel as a theory, particularly against government. I haven't analyzed it yet, so I guess, without waiving any rights to future legal claims, I'm not a big fan of estoppel, and that wouldn't be my first avenue. I think this is the Barrett versus Wiggins case, if I remember, that deals with estoppel, and it doesn't bode well for anyone trying to create an estoppel claim against the government.
Thank you, that's all I have.
Mark?
No question.
Dwight?
No questions.
And do you need to hear from would you like to hear from the applicant herself? She would certainly like to speak.
Okay,
Thank you.
couple minutes.
Good evening. I'll just be very brief since this is running a little bit long. The contention that an error has been made here is a little bit cloudy. And I wanted to also point out that not only was this permit issued in 2016, it was issued to Steve Masters, the prior owner. It was also issued to me in 2019. But the exact same facts and the exact same circumstance occurred to the original builders in '84 when they had received all of their permits and poured their foundation. After they had their foundation poured, the city went, oh, shoot, we applied the wrong setback. You're in a special setback. You can't build your house. This has been a historic problem with this property because it's non-conforming and the entire lot is in the special setback. And there are special provisions in the code that protect landowners whose entire property is in a special setback because it renders the property useless. That resulted in an agreement with the city that this home could be built and the shed preceded it. So this home and this lot has been couched in special provisions since 1984, and that's an important history for this case. The other note that I wanted to make was about this notion of rebuilding, reconstructing, demolition. It really can't be emphasized enough that this was not just a demolition that I undertook. I followed building plans that required that I not only deconstructed the building to rebuild it, but it required that I retain the foundation. Why would it require that I retain this crappy foundation from 1960s? That's kind of bizarre, right? Except that the city did know what it was doing. It required me to preserve that foundation so that I could preserve the nonconformity. That nonconformity being that I'm in a special setback. So by preserving that foundation and having to very carefully build around it and work with the building code official who came out to do my inspections, who was like, oh my God, get this out of here. This is not how we do construction. And I'm saying, no, I'm required to keep this foundation in place. So it isn't just the structural members that had to be changed to support the roof structure. And then they talked about the fact that the RID doesn't apply. Oh, the RID doesn't apply. The RID does apply. And the reason that it applied in this instance is because they approved this massive carport beam that had to fly over and sit onto the wall of the ADU, of the accessory unit. That required not only just improving it to maintain this new roof structure, but to support the weight of this carport. So this was contemplated at the time of the RID, and that's why it was tied into the RID. The other structural improvement that we don't see in the building plans is important, and them saying, oh, she just really wanted to work on a shed. I did a $300,000 renovation to that house. And I had to we added a fourth bathroom in the basement. There was already a bathroom in the ADU or in the accessory unit because it was already living space. It was already occupied and had, you know, people living in it. When we added that fourth bedroom in the basement, they said, gosh, that fourth bedroom code requires that you increase to a 4-inch plumbing line. What that required to do is trench my entire basement and rebuild the entire basement and the foundation in the primary home, dig and trench all of the plumbing and upgrade the plumbing for the ADU as well. So to say, oh, well, you can't improve anything else, that's not accurate because they issued me a permit to trench the entire foundation to put in a 4-inch plumbing main. So this is not a mistake. These were very well contemplated and laid out in plans that they handed me. I walked in saying, I'm a new owner, I don't know anything, what's going on. They helped me with the permit. At the end of it, I said, I don't even have building plans. They printed them out and handed them to me. So they were helpful, but I don't believe that this city doesn't know what it's doing to such an extent that they would produce and sign off and give building plans to a homeowner and then say, gosh, we have no idea. And it's bizarre because first it was, gosh, your permit expired, the writ expired. So we need you to just resubmit the writ, it won't be a problem. And then it was, well, you know, we put the wrong setback. We forgot that South Shore has a special setback. And then when that didn't work, they went, we got it, you intentionally damaged your structure. That's why we had to go to LUBA. That's why this is framed as some sort of code interpretation, because we had to ask the question, hey, government, your code says voluntary reconstruction is not damage. So if that's not, if there's some misunderstanding of this code, interpret it for us, because it looks pretty clear to us. So here we're stuck in this code interpretation land, and then they're saying, hey, don't make this decision favorable to her, because this might have precedent. That's a stretch. It's a stretch. So I think that's all I have, but I wanted to make those points for you to help flesh out a little bit more of those issues. So pending your questions.
Thank you. Any questions? Thank you very much.
Thank you.
Thank you, Chair, for giving her the opportunity. I really appreciate that.
Okay, we will now take citizen input. Anybody in support of the application?
Welcome to the chair.
Are you in support? I don't have a.
I came a little late, so I don't know if you got that. Yeah, why don't you
Come on up and we'll get the paperwork done. Jason, he has 5 minutes? Right. Okay. State your name and address.
My name is Brett Grantham. Address is 33040 Southeast Darrow Road, Estacada. Thank you. I know the petitioner and was involved in the transaction and the purchase of the house. And I'm a local builder and developer myself and a certified master builder in the state of Oregon. And so I just wanted to come up and make a point to say that definitely agree with what's been said here tonight, that, you know, this is something that should be approved to move forward. I've never, in 25 years in building and development, I've only seen 2 situations where a building code or building permit has been issued and withdrawn. And in the other case, it was rescinded eventually and it was reissued. So situations where they're actually given permission to proceed, you know, for construction purposes, and then removed after and left hanging. I mean, it's about as egregious as you can get. It's one of the primary functions under our Senate Bill 100 for construction and building and land use in the state of Oregon. So anyway, that's all I had to say.
Thank you.
Thank you.
Any questions? Okay. Is there any other public input in for the applicant? Okay, we have one person against, Carol Oker. Carol, you have 5 minutes.
It will be 10. I'm representing an organization. I'm representing the Fan Forest Hills Neighborhood Association.
Okay.
Thanks. And I'm not speaking against, I'm speaking neither. Okay. So Carol Okert, 910 Cumberland Road, speaking tonight as the Land Use Liaison for Fan Forest Hills Neighborhood Association, and joint with Jim Bolland, 804 5th Street, Vice Chair of the Fan Forest Hills Neighborhood Association. I'm speaking in the category of neither for nor against in tonight's public hearing, and there is an important reason for this. I confirmed today with staff that my neighborhood association received no notice of this hearing, so my board had no time to go through a process that would have allowed me to represent a for or against position. Tonight's hearing requests a formal code interpretation of code relating to nonconformities in development. The first edition neighborhood, with many older homes, has numerous properties with pre-existing nonconformities. The first edition neighborhood has been and still is undergoing massive redevelopment. Any code interpretation that potentially shifts and perhaps weakens code interpretation on nonconformities is of utmost concern to us. We actually have older properties that sit right on the property line. Yes, staff met the standard public notice code, but when the DRC is making a decision in a public hearing that staff actually notes in their staff report as being precedent-setting under item 5B2, nature of a formal interpretation, quote, the interpretation given in this proceeding will be used as precedent by staff, owners, and other interested persons regarding other developments of code provisions relevant to the scope of other proposed developments, end quote. Then it is the appropriate action for staff to do a more robust noticing to all neighborhood associations. I understand that we are officially code compliant tonight, but I want to state that there are times when staff's responsibility goes beyond meeting minimums. I hope you will echo that message. In speaking tonight, I am intentionally creating an opportunity for my neighborhood association to participate in any appeal that might follow whatever decision is rendered in this proceeding. There is reference tonight's documentation of the work of the infill task force. The Fan Forest Hills Vice Chair Jim Bolland was a member of the infill task force. I worked with Mr. Bolland today, and his signature is on this joint testimony. Jim stated the infill task force recommendation was that if 50% of a structure was removed, then it would be by definition considered demolished, and if a structure was considered demolished, then pre-existing nonconformities would not be allowed to continue. The term demolished also impacts when the city can impose certain fees on the subsequent build. The Planning Commission shifted the definition of demolished to apply when 100% of the structure was removed. Both the infill task force and the Planning Commission agreed that if a structure was 100% removed, then pre-existing nonconformities could only be continued if the structure was removed through natural disaster or accidental fire. The infill task force had consensus that lack of structural maintenance resulting in the need to completely rebuild would not allow the owner to maintain pre-existing nonconformities. Jim would like to have spoken to you directly if we'd been on Zoom tonight. There was a letter submitted into the record in favor of the applicant from Lori Friedman, who, as noted in her signature line, is Secretary of the Blue Heron Neighborhood Association. I spoke with the chair of the Blue Heron Neighborhood Association, Robert Brown. To be clear, he informed me that the Blue Heron Neighborhood Association did not meet on the item before you this evening, and that the letter from Lori Friedman is a personal position. In her letter, Lori references the city's recent Middle Housing Committee. I was part of that committee. ADUs are not included in middle housing. The setback reductions she references related to detached duplexes, triplexes, and quadplexes. The Middle Housing Committee did discuss demolitions for residential properties, and the majority supported the reference point of 50% of a structure removed to be a demolished building, impacting both fees and pre-existing nonconformities. In summary, I quote from the staff report, "Unlike a development review permit application, in a formal interpretation application, the specific site conditions are frequently not relevant to the interpretation of code text. The task is not to apply criteria to a development proposal question. Rather, the question is, what does the specific code text mean?" End quote. I've provided you context as to how your code interpretation can play out in other neighborhoods across Lake Oswego, like Fan Forest Hills. Historically relevant information with regard to the infill task force and how the current code was established, and current committee discussion trending to tightening the definition of demolish. I'm very appreciative of your time and the ability to speak here this evening. Thank you.
Any questions for Carol? Thank you. Okay, so that would be the end of our public testimony. Jason?
Thank you, Chair. Prior to closing the public hearing, any person may request an opportunity to present additional evidence. Oh, sorry. Yeah, they do get a rebuttal. Sorry, you're right.
Hey, Chair, I have follow-up questions for
Staff?
Evan. Yeah, is everybody
Okay.
going to come back?
All right. Go ahead.
Andrew Stamp, back on the record. Whether or not the neighborhood association should get notice, I mean, I think it is a good idea that all the neighborhood associations get notice when you're dealing with code interpretations. As a policy matter, I think that's not what the code says right now, but as a matter of goal 1 compliance, I think it's certainly appropriate. With regards to the 50% rule and the 100% rule, you heard a lot about that tonight. Okay, you got to understand, that all comes from, and I'm going to go back to my, there's damage right there. That all comes from Section 4. This is Section 4 of the code. And it talks about when all or a portion of a non-conforming structure is damaged by any cause other than the intentional act of the owner, you know, blah, 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 so a series of consequences occurs. You've got to understand that the definition of damage in your code says does not include dismantling of a building or site feature, a portion of a building or site feature in the course of voluntary reconstruction or repairs. So that's an exception to the definition of damage. And if you're not in the if you're outside the definition of damage, you're outside of the Section 4 in its entirety, because it only deals with things that are damaged. Now, I think conceptually that may be hard to wrap your head around. It certainly was for me. But it is clear the way it's written. And so the 50% rule, the 100% rule, if you know, all the stuff about the legislative history that Evan mentioned, that all deals with Section 4, things that are damaged. And your code says if you take it down voluntarily to rebuild it, to dismantle it, and then, what's the word? Dismantle, and in the course of voluntary reconstruction, dismantle and reconstruct, that's not damage. And that's kind of the beginning and the end of that analysis. And that's the thing that Evan missed back in April of 2020 when they issued that stop work order, because that's what he based his legal reasoning on. It's a 10-page legal memo that it was all about damage. He said, you intentionally damaged your structure when you took it down. I pointed out, it's not even controversial, that the definition of damage is very clear, and it has an exception. So I don't want to get anyone confused about the damage rule, but in this particular case, it wasn't 100% removed. As the applicant testified, they kept the foundation. And that was the thing that was the placeholder that was determined in this case to be the placeholder to retain the non-conforming use rights. So that's all I wanted to say. I didn't want to belabor a dead horse, but I think it was important to point that out. Thank you very much for your time.
Any questions? Randy?
Thank you. Counsel, I'm just unclear. So if the DRC were to adopt your client's request for the formal interpretation of these code provisions, what practically does that mean for your client? Does that mean that, in your view, they're now able to use the accessory structure as they wish? Or practically speaking, what is the impact of the decision you're requesting from the DRC?
I think the answer is yes, that they could just go ahead with the accessory structure. The applicant plans on building a carport, and so that's going to require the renewal of the RID application. And so I wouldn't be necessarily opposed to coming back and cleaning up the accessory use structure with a supplemental land use application. But I didn't want to spend all the time and effort developing all those plans if we couldn't even agree on the interpretational question, which is why I brought this back as an interpretation. Having said that, that is a development permit. It is a statutory permit under Oregon land use law. It was subject to the 120-day rules. And, you know, I'm weighing my options here as to what to do next. But I think what I'd like to do is come back with, I'd like to get this approved tonight. And if it can be as narrow as you want, I'm sensing that you guys are concerned about precedent. And I can write something that's a very narrow precedent. Just basically says, look, if you fall within that roof pitch exception to change, that you get to effectuate whatever building code is required. That's pretty narrow. That's not gonna change any. That's not gonna be an earth-shattering change in Lake Oswego. And from there, I can then submit my RID application for the carport, and we can move forward from there. So that's what I'd like to do. Does that answer your question, sir?
Thank you, yes.
Any other questions? Okay, thank you.
Thank you for your time this evening. I really appreciate it.
Evans? I usually don't like to lead off with a question, but I do want, Evan, you to cover two things, one briefly and one as long as you want. But we have a couple of new members on the commission. Could you just give us a quick overview of a RID, one, so they understand, and two, address the 120-day issue.
All right. Overview of RID, and of course Jessica, the planning manager, can fill in, Evan as well. A RID is a type of variance. It is a design-based variance, and the purpose of a residential infill design, that's the RID part, residential infill design variance, is to allow modifications, variances to the code requirements, provided that the applicant can demonstrate that the design of the building results in better impacts, if you will, to either the neighborhood, the neighbors, to the streetscape, and the building mass. In the building mass. So, for example, I mean, if you're having a setback, you're intruding into the front yard setback by, say, 5 feet. It could be that your design is such that, kind of like when you compare it to what you could do, kind of thing, that this design is better than would be permitted under the code. If what would be permitted under the code might be a straight building face elevation to it, but if I go 5 feet in but slant it back some, that may be better, okay? And if I put some architectural details, details to it, that might also have some advantages to it. Perhaps some window treatments, and I mean, they get into design things to visually reduce the impacts. And then also on the side yard setbacks, sometimes the placement of windows is important because the neighbor then doesn't have the potential for noise as opposed to otherwise. So it's a design-based thing as opposed to the other major variance or minor variance, which is a small deviation code. This would solve it by design. Your second question was 120 days. Oh, 120 days. Well, frankly, it's not applicable. I mean, it's not an issue for the DRC. If the 120 days is violated, the first question is it applicable? Okay, I reserve that question. If it is applicable, then the applicant has the opportunity at any time during the process to file the petition in circuit court to have it reviewed there. okay? So that would mean that the DRC wouldn't make the decision, it would mean the city council would make the decision. But as long as, until it is, you make the decision. Okay? Now, I have some other items I wanted to, basically, it's, the format of this thing is obviously a little difficult. It doesn't quite follow the applicant-opponent situation here, because we have staff is somewhat the opponent, you know, if you will, and we have an application, we're responding to it. And so he's made his statements, and I need an opportunity for rebut, and I can either do that in this proceeding, or we'll have to ask for continuance in order to do that. So either way.
I think we'd like to hear it. Jessica, did you want to say something?
No, I didn't have anything to
Oh,
add
okay.
unless you had a question for me. No.
Okay.
Thank you, thank you. The other thing is, are we gonna have a continuance because of the packet of information that was received tonight from?
I think what I hear is we don't need that. There was only one letter that I know is new, and I'll submit that.
And can I see
So that is new information that we did not have previously.
So the rest of the information you got, Mr. Shedd, we don't need to get it into the record tonight. You're withdrawing it?
Yes.
Okay. All right.
Well, I have to read it to see what we're gonna do, I mean, whether we're gonna
Yeah,
ask for
I understand.
continuance.
Well, wait, the staff's not a party, so they don't get to decide anything. Parties get to ask for continuance, not staff.
Says any person make requests, and I think.
No, you're not a person, you're staff.
Well, we'll leave that for ruling the chair then.
Jason, can I ask you about that question?
Whether or not someone from staff can ask for continuance?
Yes.
It says any person can, so yes.
Okay.
Now, the question is, do we need to? And I'm asking Francis to take a look at it, having Francis take a look at it. The question is there new evidence here that we haven't had an opportunity to look at?
Yes,
Is this a letter in support of the?
This is
Yes, this is a letter from the building forensic testimony that you heard, mostly about the building code, which we have not had a chance to look at. This is new information. It would be nice to have the building official look at this.
Can I make a point of order?
You know, so here's, you've submitted something tonight, and it comes in front of staff. We haven't, as a commission, we haven't seen it. So as far as I'm concerned, my thinking is either staff has a chance to review it and submit it to us, so we can look at it, which we're not gonna do tonight, or you withdraw it.
All right,
And,
I'll take it back.
okay,
But the answer is, there's a case called Multnomah County versus Multnomah County. I know because I litigated it.
What was the question?
I'm sorry.
Staff is not, they don't have any rights.
You're out of
under-
order right now,
Okay,
because what I'm saying is, you know, staff isn't gonna make this decision, we are.
That's fine.
And if we haven't had a chance to see something you submit, if it's important enough for you to submit it, then we have to be able to review it. That's my point.
Okay,
And
I understand.
I don't want to get in a conflict between the city and what the city's doing. It's really what, you know, if you're submitting something, you want us to see it. So if, and we need to be able to look at it and think about it. Do you understand what I'm saying? Good. Okay. Evan.
Okay, six quick points here. I want to make it clear that the staff did not mandate that they change the roof pitch. I mean, there were three options there. If they wanted to do anything, they didn't have to do anything. I mean, you know, so it's not like staff is mandated. And on that note, the applicant has said that the schematic bubble that was added, where it says garage walls have to be rebuilt due to new roof structure, that is not a planning department notation. That's their architect or designer type thing. So that's what they plan to do. That's why they want to do it. So, okay.
Wait a minute. That was I was going to ask you that question. So that bubble or cloud was, so the drawings that you have there are the first permit.
Yeah, let's have.
Yeah, that's right.
Brian.
And so then when the second building permit came along, somebody evidently looked at it, a professional, architect, engineer, and put that clouded statement on there, correct, Brian?
At the time this plan was reviewed, we did not have digital review capabilities. So we did not add those notes, that bubble, on these plans.
But you don't do that anyway.
We do now. We do digital stuff now.
Okay.
But at the time this was reviewed, and by the way, I was not on staff when this was planned.
I understand.
I was not the building official at this time.
Yeah, what the bubble represents is a revision to
Yeah.
those first plans.
But the revision wasn't mandated by the city, that's all you're saying?
No,
Okay,
it's
thanks.
just yeah.
Yeah,
Okay,
good.
all right. As far, I think the applicant has said you should make some policy here tonight, and of course, that is not the job of the DRC, and you interpret the code and what was intended by the code is, and it's not to decide what should be the policy. That policy has already been made by the Planning Commission and City Council as you interpret what they did, okay, but not to put your own policy imprimatur on it. The foundation is probably compliant, because anything that is at grade level is compliant with the setback. The question is if obstructions from the ground to the sky. Are there ripple effects? Well, there could be some ripple effects when you're dealing with remodeling structures, and of course, you have to comply with the building code and the planning code. I mean, it's not one trumps the other. Was the city negligent? What I said was the city probably improperly issued the building permit on our code interpretation. Now, whether that's negligence, there are additional factors to that. I'm not saying that this is a confession of judgment type of thing. Will this thing have precedence? Well, you just heard, I think this would only apply to non-conforming structures that the applicant wants to tear down and put roofs on, and justify by putting a roof on. Well, I think that has broad application on it. But the fact that I never told you about the underlined sentence on damage, because I think it's not relevant, okay? And the reason I think it's not relevant is because it only, as Mr. Stamp indicated, this is the term, it relates to the term damage, and that damage only appears in Section 4, which talks about damage and reconstruction. What he's asking the commission to do is to rule on whether or not this is permitted under subsection 3, which had to do with the change in roof pitch. So the word damage isn't even in that section, so it's not relevant to it. This gets to whether or not the damage in section 4, that's damage and reconstruction, whether it's intentional or unintentional. But that's not, they admit it's not a section 4 question, so that's why I'm not hiding anything. I think he's quoting out of context and trying to piece together things in different sections of the code to do it. And then lastly, there was some testimony about a 1984 agreement, I think, something like that. That's not an interpretational question. I don't even know about this purported agreement, but it's not on the record, and we don't know about it.
Okay, thank you. Craig, did you have a question?
Yeah, hi, Evan, is there, we're saying this would affect 4,000 square foot residential home if we find this ambiguous, or is there any code regarding accessory, shed, garage, under some certain amount of square feet? Does the city look at a smaller, call it non-primary structure?
I think Jessica's prepared to.
Yes, the city does have accessory structure standards in a couple of different sections of the code. But all of those structures, any structure over 30 inches above grade, the issue here and the reason why this is a non-conforming structure is that it doesn't meet the special street setback. And all structures, regardless of whether they're primary or accessory, are subject to that special street setback. And unfortunately, you cannot get a variance to a special street setback. And most of the structure is within that special street setback area. It's also in the side yard setback, which accessory structures have side yard setback requirements too. But yes, there are separate standards for accessory structures, but regardless of whether it's an accessory or primary structure, this structure does not meet those standards.
And the point to the precedent point is there's nothing in section 3 which talks about change on roof pitch that says it only applies to structures that are in the special street setback. I mean, there's no cabin there. There's no way to cabin it to say it only applies to structures in special street setback on a small lot in a side yard. Okay, I mean, so it applies, the precedents would apply to, the interpretation would apply to how we apply the non-conforming, to all non-conforming structures. Now I take, by the way, I take the first edition neighborhood's comment, yes. They didn't get specifically notified, and then they acknowledged that we've complied with the code because it's kind of like property specific. It's the same thing that happens, as you brought out, when the planning or the DRC makes an interpretation applying the code in a regular application before you. I don't know what example would be, but well, building design, I guess that's good. You guys haven't, excuse me, the DRC has, with staff, has interpreted the scope of building design, okay, as to adjacent buildings of good design. Well, that interpretation has now been communicated to other applicants, and what that means, so they prepare their application, what they have to do. So that's the way interpretations get made, and if the interpretation's wrong, it said the only way to do it is to overturn by the DRC or by the city council or change the code.
So just to clarify that if I have a shed on my property or a small garage or something, an accessory unit, and I make some modifications to that, as long as I'm doing it within code, it would comply under the accessory. What changes this is it's out, the setbacks are out, it's non-compliance, which throws the wrench into this.
Well, I'm sorry, so I'm sorry, repeat what.
So you mentioned that because the property with the accessory is non-compliant, non-conformance, right?
Yes, this
It's
accessory
outside of
structure
the
does not comply with the side yard or
Right.
special street setback.
So it doesn't, it's not going to be considered as an accessory because it's in that.
Well, no, it is an accessory structure, but it's non-conforming because it doesn't meet those standards.
Okay.
Yeah, if it did meet all the setbacks, then, yeah, the non-conforming section wouldn't apply, and you could just rebuild it per code. It wouldn't be an issue. But I think
Does anybody else have any questions for Evan? Or Seth? Go ahead.
Getting back to this issue of precedent, and I'm sorry to dwell on it. So, Mr. Boone, I understood you to say just now that with respect to precedent of formally interpreting the code as the applicant requests, that the precedent wouldn't be limited just to this, whatever this area is called, special setback or special area that this house is on.
Special street setback and side yard setback.
So wouldn't the precedent just be limited to that?
What, the precedent's
To
limited.
those circumstances going forward?
No, what makes it non-conforming, okay, is special street setback, but property can be non-conforming for other reasons. So once the property is non-conforming, that's what we're here, if property is non-conforming, then the question is, what can you do with it? Can you maintain it, continue it, expand it, change it? Change is what we're here tonight on. Or what would happen if it gets damaged by either intentional or unintentional means. So it's not the trigger that makes it non-conforming, it's what you can do with a non-conforming structure is what the issue is for the commission.
I see. Thank you.
So we couldn't draft a finding that was narrow enough to only affect this lot, is what you're saying?
Well, you heard Mr. Stamp say that he thought he could, and then when he described it, it said.
No, that's not narrow enough.
Yeah, when he described it, he couldn't.
No.
So I can't either, and that's why I bring it up, that's why we brought it up. It applies to any non-conforming structure, wherever it exists in the city. And again, this is not unique to to a formal interpretation, many interpretations come through the application, and you guys review that, you review it, and then you make your interpretation, and we follow that interpretation. It's not a one-off interpretation, because we assume under the same facts, same material facts, it would be applied uniformly. The material fact on this is the structure is non-conforming, and then the question is whether you can demolish a structure in order to end up with a different roof pitch.
Anybody else have any questions?
Okay, thank you.
Thanks, guys. I think that takes us on rebuttal.
Thank you, Chair.
Now it's up to you, Jason.
I'll go back to my script here.
Sorry, I left my outline at home.
Prior to closing the public hearing, any person may request an opportunity to present additional evidence. If a request is made, the public hearing shall either continue to a date certain not less than 7 days later, or the record shall remain open for at least 7 days after the hearing to enable additional written evidence or testimony to be submitted. And the commission shall establish the period for any rebuttal written evidence to be requested. At this time, is there any request to present additional evidence? Unless waived by the applicant, the commission will allow the applicant at least 7 days after the record is closed to all other parties to submit final written arguments in support of the application. This information shall be considered part of the record, but shall not include any new evidence. At this point, to the applicant, do you want to submit final written argument, which would delay?
I think we'd rather get a decision tonight, I think. I think the issues are laid out pretty clearly.
Well, at that point, then I turn to you, Chair, to conduct deliberations.
Okay. Dwight, you look like you have some ideas.
I'm going to use the prerogative of the new member. Would you describe in very brief form our responsibility from this point in the hearing to making a preliminary decision with a vote? Are we to discuss and craft a resolution? Is that our responsibility? We have not been offered help from either side, so that would be in our bucket.
Correct.
And then we would have the normal review and confirmation and so forth process beyond this, at which point a decision becomes formal from us and is then subject to appeal or whatever subsequent action within this structure of decision-making.
Right. Anything that we decide tonight can be appealed to the city council, and then it can go from there up to LUBA and wherever else.
Yeah, I apologize for my poor and unprecedented attempt to describe what I think we're doing, but I think you get the essence of my question. Yes. It is our job to craft a decision that we will then agree or not agree on.
Right.
Thank you.
Any thoughts, guys?
I guess I'll go first. Start the loop. Just going at ambiguous codes, a non-conforming property, some mistakes made, very unique property, some confusion along the way, all that is wrapped up from hearing all the testimony. It's a tough one because I don't want to set a precedent, but I also feel there's a very unique situation here. So, at this point, I'd like to hear from the rest, the commission, and go from there.
Randy, what are you thinking?
Well, thank you for calling on me. I actually am reluctant to approve the applicant's request. I think this matter does, whatever we decide, we may have the power as the DRC to interpret what this code means. But I am persuaded that what we do here tonight will have only marginal impact on the applicant who has other proceedings and forums and states they have a prima facie case. The city says if they've made a mistake and are found liable, that they will respond. So it seems to me that we're being asked to legislate on the questions being presented here. And I personally am persuaded that that's something that I'm going to vote no if asked to vote on the application. And I think this would be something that we as a DRC should ask the Planning Commission to address, this question about what does that 6-foot extension of the roof line mean if you can't replace the supporting structure to accommodate that. So I'm going to vote no, and I think I would defer this to the Planning Commission and City Council to address. And the parties have other forums to address their dispute in. That's what I'm thinking.
Okay. Bruce?
I agree.
Gentlemen? Mark? Dwayne?
Yeah, I have some comments. I think I can easily separate two issues. There is an issue, which I thought was the original presentation, of our interpretation of the code. There's a separate issue of perhaps a legitimate and sustainable grievance on the part of these appellants who want to have something done that was not done. I don't think that is our responsibility or jurisdiction at all. So I'm focusing on the single question of whether I see anything in the code that has been reviewed here that I find to be unenforceable, ambiguous, whatever, and I do not. So I will vote no. But I would comment that there was a comment made before, I am a civil engineer, and I am confident that you could structurally support the roof that is on that current building without having to modify any of the exterior walls of that structure. That could be done structurally. Now, it may well be, reason to improve the code, but in terms of supporting a 6-foot roof within that original structure, it could be done. So I'm going to vote no.
Doctor?
With respect to the question of setting or not setting a precedent, we don't have a choice, because either way that we do this, we do that. I'm not a structural engineer. It does seem to me that the modifications in the structure do have sequential, consequential impacts on structure, walls, and foundation. And I think that there was sufficient evidence to convince me that that was the case. And I will vote, depending on how the wording of the resolution is, in favor of the appellant.
Well, I think the code is really ambiguous. I think it's, I don't think it's very well spelled out what's expected from the planning side of things. And, the trigger of the nonconformance being the special setback for South Shore. I guess my feeling is that 6 foot, raising the roof height 6 feet, opens up Pandora's box, in my thinking. Because there's lots of roofs, if you have a flat roof and you're going to a pitch roof, whether it's, trussed or gabled or as we showed a shed roof, it changes the whole structure. Now, I don't know how the city's interpreted in the past, but I really don't feel comfortable making that decision here. I really think that our decision is, I'd like to make it as narrow as possible, because I think this is something that's gonna impact the whole city, and it needs to have some review beyond where we are. So for that reason, I would probably vote against this application with Randy. That doesn't mean I don't feel that these people haven't been impacted, because I think they have been. I just think it's a bigger problem and needs a bigger review than what we can do here tonight in 2 hours. That's my thoughts.
If we vote yes, and depending on how this is worded for the appellant, does that just put a job for the planning commission to get to work on correcting the code as best they can, if possible?
You know, I think Randy or staff can answer that better than anybody, but I think their program's pretty full, isn't it? Just because we make a decision.
Yes, I wouldn't, if you're addressing me, Chair,
Yeah.
I would not expect the planning commission to give this high urgency, but I can't speak for Chair Heap or the planning commission or planning department, of course.
Okay, boys, you know, we signed up for this thing. You know, we gotta make a decision. Anybody like to make a motion? Randy?
I will move that the DRC deny the applicant's request in the nature of the formal code interpretation of non-conforming structures that they're requesting as set forth, which question is set forth in the August 27th, 2021 staff report on this matter.
Is there a second?
Second.
Any discussion on,
Yeah, can you work on the wording of that a little bit? Can you rephrase that? It's not clear to me what you moved.
would you like to withdraw that and take another run at it?
Yes, I move that we not make a code interpretation as requested, but defer it for action at the planning commission.
That's not really the question, is it, council?
No, the question is to deny or approve, not, I guess I'm not sure what.
So my motion really was to deny the request as submitted, period, and I don't know.
That's different than what you originally said.
Okay, well, that was my
That's why
intent.
I'm asking for this.
Yeah, that was my intent. So I would rephrase it, withdraw and rephrase it to say, my motion is that the DRC deny the applicant's request as submitted.
Okay, so if I get this right, your motion is to deny LU 21-0016, period.
I'll accept that, yes.
Is there a second?
I'll second that.
Is there any discussion on the motion?
Are you clear, Commissioners, Doctor, are you clear on what the motion is?
Yes, I am.
Okay.
Okay, seeing no questions, Kat, can you pull the commission?
Just to be clear.
Yeah.
Just to be clear, a vote of yes
Denies it.
denies this. Very good.
Denies the applicant's request.
Yes.
Shear,
Yes.
Arthur,
Yes.
Silent,
No.
Berardi,
No.
Poinsett,
Yes.
Sangre.
Yes.
Okay,
4 yes, 2 no.
thank you. This is a difficult decision for us, and I don't want it to reflect on how we feel towards the applicants. We think, we understand this, you're in a tough spot. Okay, so we move on to the next item of business, which is schedule review and management update.
Thank you, Chair. The next DRC hearing is on November 15th, I believe. Excuse me. I had 18 come in my mind, but I believe it's the 15th.
And, right, so this is a tentative decision, right?
Yeah.
Okay, so it would be adopted with written findings at the next.
Correct. And that is Monday, November 15th at 7 p.m. We do have one other item on the agenda for that evening, and that is a public hearing on some new apartment buildings off of Parkview Drive. I do not, as of right now, have any items scheduled for the month of December, but that can change if any applications go complete before then. And that's it.
Okay, we're adjourned.